Item number 1.
May I please, Your Lordship?
So there's nothing in the matter, Mr.
Fine.
Mishra?
May Your Lordship will decide that.
All right. You say this petition had been filed at a stage when there was uncertainty about the proposed new building for the district court premises in Bhadrak. With the subsequent developments and with the opening of the new court building being imminent, with the consent of the present petition has been rendered infructuous and is disposed of as such.
Obliged.
Item number 2.
May I please, Your Lordships? Your Lordships have been pleased to dispose of similar writ appeals, my lord, arising out of the same judgment passed by the learned Singhi judge. I have passed on the judgments, my lord. There is some delay in filing this petition, my lord, IS 7 of 2021. The Lordship have been pleased to hold that the contract was not complete and pricing policy is executive action. Therefore, your Lordships were not
Dismiss the
inclined
appeal.
to.
All right. The delay is condoned in view of the order passed by this court on 21st October 2021. In writ appeal 764 of 2020, bracket Prabharanjan Mahapatra was the state of Orissa. The present appeal is dismissed. All right.
Item number 3.
May it please your lordships. Lords, in this writ application, I have challenged the action of state authorities in not allowing us to operate the fisheries which we are operating since generations, my lord. If your lordship have
Yeah, last time it was other bench.
no, it was registered before, not.
Why is it today?
I do not know, lords. It can be listed before any bench. I have no objection about.
No, because it was earlier listed before the bench number 2.
I see.
My lord, perhaps it is relating to that Chilika issue. If
Yes.
Fisheries
then it
islands.
can be tagged with that PIL, so which will come on
No,
7th.
my lords, there is some difference. My
No,
lords,
there is no
PIL,
difference.
please hear me first, then don't comment, please, kindly. My lords, this is relating to a fishery right of some persons after the bifurcation of the district and the area has gone to Khurda district and some of the people from this area have settled there. Now they are demanding the entire fishery to be given to them. If your lordship will kindly turn to two pages, if your lordship will kindly turn to page 32. I have quoted from a book of the then director of fisheries. There are 3 villages, lords, page 32, my lords may kindly see. Jagul Padar on the top. This village being a population of so and so, my lords. So these fellows are catching fish from Doya river, from Jonkia God to the neighboring, to the mouth of Subhadrapur fishery, my lord. So this Subhadrapur has now gone Khurda district. So they are now going to settle entire fisheries to Khurda person. So that is our difficulty. We are living from generation by fishing from these areas.
All right. Anyway, you file a reply here.
Yes, my lord, the reply. I am not saying anything else.
My lord, I would file reply, but there is no difficulty if you can tag this case with
No, that
because
is,
these are all.
no,
Let
that
it
is Gary.
You complete pleadings here and then we see.
That is Gary, my lord.
Auntie accepts notice. Also for Registrar of Cooperative Society in Orissa.
Yes, he can note.
Yes, I can.
And Chilika Development Authority.
Fish paid, no, 7, 8, they have to issue notice.
All right. 1 to 6, 9,
And 13.
9 to 12. Yeah, he accepts. Then notice be issued to 7, 8, and 13 by speed post returnable on the next date.
Obliged.
As we filed. This pro forma opposite parties are who?
Because they are supporting us. Because there are 3 villages, they are fishing in one place. They have also
No.
filed another writ, but here they have been made pro forma for. They have also filed another writ.
When is that writ coming up?
That I'll mention it tomorrow because immediately I can't give the number. I will mention it tomorrow.
All right.
I'll mention it tomorrow. Before it will come before your last.
Replies be filed within 8 weeks of the service of notice. Rejoinder before the next date. List on 3rd February.
Obliged.
3rd February.
Obliged, my lords.
All right.
Item number 4. Item
My
number
lord,
4.
item number 4, may I seek an password, my lord? My learned senior is on his legs.
Yes.
Only one password.
Item number 5.
May it please, Milords. Milords, this is a petition challenging section 148 notices issued in the Income Tax Act. Your Lordship, I have given similar orders passed.
All right.
Yes, my lord, I have filed my memo of appearance, my lord. Lay extra copy this order.
All right. Mr. Mahapatra, same.
Obliged.
Obliged.
Item number 6.
Please, your lordship. Item number 6, your lordship. I am challenging the appellate court order by the excise commissioner, your lordship. The small facts, the very brief facts, your lordship. I am the licensee of Langeshwar Moja, your lordship, Panchayat. It was directed that I shall open the shop but I, because of staunch public objection, I had to open at B, which is under this 2 kilometers difference, your lordship. One of the in the same area, one operation in on-shop licensee preferred a bit application, which this honorable court asked the collector to consider the representation, your lordship. The collector asked me to go back to shop number A, different mood, your lordship. I filed the petition before this honorable court for extension of time, your lordship. Your honorable was extended for 1 month, your lordship. Subsequently, I challenged it before the appeal court, wherein a policy has been changed that if your lordship sees at page 37, your lordship. Page 37, if your lordship may kindly see. Wherein it has been introduced in this year that if you want to shift from place A to place B, you pay a fine of rupees 1 lakh and you are allowed to do so. I approached with the same representation before the appellate court. The appellate court said, because you have come before the honorable court and asked for 1 month time for shifting, now you cannot take that ground. My humble submission, your lordship, is estoppel will not be a barrier to me because the policy decision has been introduced by the state government by this for this financial year. So I am under that category, your lordship.
My lord,
And one more thing, your lordship, if your lordship sees I have already pleaded and I have annexed, the local have supported me to continue at plot B, not at A, because I do not find a single place unobjectional site at the initial place of opening of shop, your lordship.
my lord, in reply, I would like to submit to your lordship. This writ petition is only filed to circumvent the order of this honorable court and to get rid of a contempt proceeding. What has happened, my lord? There was a order to dispose of the representation.
Right.
The representation was disposed of.
Somebody
was-
else's writ petition.
Pardon, my lord?
Not in his writ petition, somebody
No,
else's.
some other. That is in the impugned order, it is mentioned.
Correct.
And in that, writ petition was dismissed and the collector has issued shifting order and they have filed an extension petition that kindly give me some extension. The honorable, your lordship passed an order that 1 month time is given to extend the time period for shifting, and without adhering to the order of this honorable court, without shifting the period, he again filed another representation that and suppress the fact that I have obtained the extension order of this. So the commissioner in the page 38 annexure 9.
Yes.
It appears from the record, last para I am sorry, it appears from the record that the appellant had filed another application before the Honorable High Court of Orissa, registered as a WPC number 2639 of 2021, challenging the order dated 13/8/2020 of the collector Ganjam. The application was disposed of on such and so with a direction to the petitioner to move the collector Ganjam, praying therein for extension of time to shift his shop to an unobjectionable site. Accordingly, representation was filed to the present application before the collector Ganjam, which was considered and disposed of by the collector on 18/9/2021. The collector Ganjam had allowed the appellant a time of 1 month from the date of order to shift his IMFL offshore to an unobjectionable site with a condition that if the licensee fails to select a suitable site to shift his shop within 1 month, necessary action will be initiated as per law. These facts have not brought on the record by the appellant, rather the fact was brought on record by Ms. Anjali Sahu, who is the complainant, in his factual report by number so and so, and collector Ganjam in his factual report. In that view of the matter, this appeal is now infructuous as the appellant has himself accepted the shifting by virtue of his representation before the collector Ganjam, on which the collector Ganjam had extended a time period of 1 month. So he accepted the shifting order, applied for extension, approached the Honorable High Court. Honorable High Court directed the collector to consider the extension application. Collector has given him extension of 1 month. Thereafter, without adhering to the order of the shifting order, he has again filed this representation and appeal.
Yes.
So that is, yes, my lord.
Yes, Mr. Padigree.
Yes, Your Lordship. There is a differential I want to point out, Your Lordship.
Yes.
Coming before Your Lordship for extension of time to find an unobjectionable site, Your Lordship. Admittedly, by the Panchayat Sarpanch, they have objected to shift to plot at A, where I was forced to open at plot B at the initial phase, Your Lordship. Only on record it
See,
has
on
to
the
be.
same on the same cause of action, you can't have repeated requests.
Yes, that
No,
is
it is
my
not same
solution. Same cause of action.
Let me complete my learned senior. Please let me complete. A question has been posed to me. Please. Your Lordship, may kindly, there is a policy which has been taken up. I have not challenged it on merits, Your Lordship. I have said that I will find, if Your Lordship sees, I will read out Your Lordship's order. There a petition was made for to find an unobjectionable place to shift. Your Lordship was kind enough to grant me 1 month's time. Later on, after I could not find an unobjectionable site, I rely upon a policy made by the state government where you can shift if there is no objectionable state by paying a fee of 1 lakh rupees. I am ready to pay. What is the harm? If there is no objection, because
this policy is
Cross that
there.
stage, Mr. Pani. Over now.
Your Lordship may kindly, because estoppel will come only against me when the other party has acted upon my actions, not before that. Here, the state government has not acted upon. That is one, Your Lordship. Secondly, the first writ application has been filed upon which the collector has ordered is by a competitor of me. He wants to take the whole business of mine, Your Lordship, because he very well knows that plot number A is totally an objectionable place. I cannot open a shop there.
My lord, my response
The
submission
policy
is that
has to be. I am only asking you.
this policy was very much there from the beginning.
Policy,
You note that it's a new policy of the state government.
All right.
So far as shifting matter is concerned, it is already set at rest. You
No,
cannot
no.
re-agitate it. It's the same cause of action. That is already decided that you are bound to shift the. Now you have
The
to find
policy
out
has
the
never been
unobjectionable
decided.
site. You have taken the extension of time period. Now to circumvent that order and to get rid of the contempt proceeding, you have again filed another application. Without disclosing that, there was an order of the Honorable High Court allowing him to extend the time period for 1 month.
Here, Your
And the
Lordship.
commissioner has passed the order on the basis of that only. What is the infirmity in the impugned order? That is my
Your
response
Lordship,
submission.
the implementation of policy was never decided. Whether I will come under the policy
Then
or
you
not,
should
has
have
never been
edited
decided
this
by
point at the very
collector,
first
not by
instance,
the appellate court.
not in the second, third, fourth instance. In the
All right.
edited this.
All right.
It was never my application, Your Lordship. So my humble submission, Your Lordship, is policy is there for the favor of the licensees. I am unable to run a business at plot A. I have to run it at plot B. So if the policy accepts me to do so, what is the harm to the state government? I am there getting the
Harm is
revenue
that
of
there
all
is
that.
heavy public objection which was considered by the collector Ganjam,
There is
and
no
accordingly
public
the
objection.
shifting
Your
order was
Lordship may-
passed.
Your Lordship may kindly.
And that is already final.
Your Lordship may kindly say that if there is any public objection, I will not shift
No,
to
no. We can't now start all
Now
over
you
again,
can-
please.
Your
That is over.
Lordship, if
That
Your
is
Lordship
always-
sees, I filed a similar petition by the Sarpanch that they say that they have public objection at plot B and not at plot A. The Sarpanch has filed it, Your Lordship. Your Lordship may kindly issue notice to that effect.
Yes.
If they have public objection at plot B or plot A.
Yes. Where is this court's earlier order? You not annexed it.
That is not annexed. I was also.
Your Lordship, if Your Lordship permits me, I will read out, your lordship.
What is this 28141 which is pending adjudication?
That is after the initial order of the collector, I filed the petition. It has now been rendered because I have gone on appeal. That has already rendered infructuous. So my humble submission, your lordship, if there is public objection, I am not there to, your lordship, issue notice to opposite party number 7, who is the Sarpanch.
No, Sarpanch is not the only person of that locality. You have got or catch hold of that Sarpanch. That does
along
not.
with anyone, your lordship, anyone, all the ward.
No, that is already over. That is already over.
That is the representative, your lordship.
The shifting order is since long. You are not obeying the shifting order and filing the cases one after the other. You are seeking extension on one hand, again you are challenging the same order.
If a order has been made by the collector, the whole judicial system will collapse, your lordship. And the appellate court is therefore challenged, your lordship. The whole 2021-22.
Once you have asked for extension.
If your lordship permits me that if the collector give me one opportunity to show that implementation of this new policy has not been carried out, then I have no case, your lordship. It has to be carried out, your lordship. It is for our benefit. And equally to the revenue will be generated to the state government. If it is not carried out, then the whole policy will of no use, your lordship. Nowhere in neither by the collector nor by the appellate court.
No, Mr. Panikkar, you were definitely a party to 16765.
Yes.
You were implemented as an opposite party there.
Oh. 167. Yes, your lordship. The initial first
you were obviously implemented as an opposite party.
No, on the first instance, it was disposed of without notice by saying that the collector shall consider, your lordship. I was never a party. I was a party, but it was disposed at the first instance.
No, you were a party. You did not challenge that order.
Pardon me, your lordship.
You were a party to 16765. You must have been implemented as an opposite party.
Yes, your lordship.
You did not question the order passed by this court disposing of that petition on 17th May 2021.
I was never given notice, your lordship. It was disposed on the first instance.
No. You were obviously aware.
No, never, your lordship. It was only when the collector issued notice to me that why it shall not be shifted.
Therefore, you were aware. Therefore, you were aware.
He is aware he sought for extension.
Yes.
Only before the collector, your lordship. Not it is the, your lordship, may kindly, I have almost invested 40 lakh rupees at opening of the shop, your lordship. Now, finding everything will be very, very hardship for me, your lordship.
Yes.
And if the policy is backing it, then why should it not be considered? I am posing a question to myself, your lordship.
Yes.
Only to that aspect, if the collector gives a reply. If there is any other hindrance, apart from being negated by estoppel, if there is any other hindrance, then I have no case, your lordship. And here also, estoppel will not be affecting me.
You're not enclosing any of the earlier orders.
I have not quoted your lordship. Your lordship order on the last occasion for extending of time, may I be permitted to read out, your lordship. The only grievance the petitioner makes at this stage is that he needs some more time to select and move to an unobjectionable site at the approved Moja.
That is what you told the court. Now you want to change that?
No,
that order has not been mentioned here.
Yes.
No, had there been so?
He's vaguely said it's been disposed of. Correct. Well.
Yes, your lordship. To find an unobjectionable site, I could not find. That's why I come before your lordship. That because I could not find the unobjectionable site, now I had my lordship's mercy that to implement the of the policy. Because the policy is in my favor, your lordship. It is only a payment of 1 lakh rupees. I am ready to pay. And the public is in support of me, your lordship. To open at the
you should have thought of all this before you made that statement before the court on 9th September.
This is
virtually like a review petition. This is a disguised review petition.
Yes.
No.
Yes, please.
Just to overcome that order.
No, it is after that.
Deliberately, he has not enclosed that order.
No, no, it is. I am, because it's a difference of counsel, Your Lordship. I'm sorry to say that.
No,
But it is a difference of counsel which could not be. And that is one part. Second one, it is after the appellate court order I have come, Your Lordship. I have, before the appellate court, I have tried to impress upon the appellate the commissioner that the policy is in my favor. So let me continue with at the present side, paying 1 lakh rupees.
My lord, one thing I don't understand, if it is found on merit that it is an objectionable site and you cannot run there, you sought for extension. Thereafter, where is the question of imposing penalty on him and allow him to run that place?
My learned senior is that it was never an
You cannot insist us to do one thing, even if it is, but
no, it is not an
actual
objectionable
circumstances.
site.
We have
It was
taken
never
already
an
taken a
objectionable
decision.
site. The whole consideration is that because the plot A was named, was stated to me at initial stage of giving license, and plot B was never in the paper, so I have to sit back to plot A. It was never a question of objection or non-objection. It was never into consideration, Your Lordship. There my learned senior is wrong. That was never into consideration by the collector, Your Lordship. Whether I'm continuing in the
extension
objection side
order
or
is
non-objection.
placed before this honorable court, there will be no scope for my learned friend to place all this, because that extension order is very speaking order passed by this honorable court. He has given undertaking.
Your Lordship
He has given
granted me
undertaking
one
before this court.
find an objection, unobjectional side, and shift. But I could not find an objection side. That's why I'm requesting Your Lordship to extend that policy in my favor, Your Lordship, because I could not find an unobjectional side. That is what I'm saying. Your Lordship had extended 1 month time to find an unobjectional spot and to shift. I could not, because I could not find an unobjectional site.
No. You have given, that is not that. It is in either way. You have given undertaking to the court that I will shift to a unobjectionable site.
Yes, I could not find it. That is what. To find the unobjectional, I could not find it.
All right.
Because the local law.
Unless that order is reviewed or recalled, how this repetition is maintainable?
It is an extension of time, Your Lordship. It is not reviewed. It is an extension of time to find an unobjectional, which I cannot find. That's why that 1 month has lapsed. Because let me continue by paying 1 lakh rupees as per the policy.
No.
All right. Now we've heard all of you enough. See, the petitioner.
Your Lordship, may I make a small prayer, Your Lordship? Let it remain back to the collector on this aspect only, Your Lordship. Only this aspect.
No question. It will all come to an end. The petitioner was to set up an IMFL offshop at Langleshwar in district Ganjam. It appears that instead of opening the said shop at Nagardiha Patana Mauza, the petitioner opened it at Patharkata Mauza. As a result, a show cause notice was issued to him. This was revealed when an inquiry was ordered. Full stop. It may be noted here that opposite party number 6. Who's 7? Why is 6 and 7 made parties? Who's opposite party number 7?
They are all complainants, I think.
No. I think opposite party number 6 had a competing shop.
Yes, Your Lord. He's a conflicting shop, Your Lord.
Opposite party number 6 is a licensee of an on shop.
Yes, Your Lord.
At Langleshwar. According to the petitioner, this on shop is only 2 kilometers from the off shop of the petitioner. Full stop. Opposite party number 6. Objected to the petitioner's continuation at Moza Patharkata and filed writ petition civil number 16765/2021. That was disposed of by this court on 17th May 2021 on the very first date, with a direction to the collector to dispose of the representation of opposite party number 6 within 3 months. Full stop. Paragraph. The collector bracket opposite acting on the above direction of the court, this court, disposed of the representation on 13th August 2021. Full stop. The consequential direction was issued to the present petitioner to shift his off shop from Patharkata Mauza to Nagardiha Pattana Mauza under Langleshwar GP within 1 month. Paragraph. The petitioner then made his own representation to the collector on 27th August 2021, asking him to reconsider his decision since he was unable to find and single quotes unobjectionable site, unquote, at Nagardiha Patana Mauza. The petitioner then filed writ petition civil 26391 of 2021 in this court. So that came to be disposed of its court on 9th September 2021, recording the plea of counsel to the petitioner that the only prayer he was seeking at that stage is for further time to shift his shop. So noting that submission, this court disposed of the writ petition by the aforementioned order dated 9th September 2021, granting the petitioner extension of 1 month for the purpose of finding a suitable place to shift the shop. Paragraph. The petitioner then filed a second writ petition, being writ petition civil 28141 of 2021. It is stated by Mr. Panigrahi, learned counsel to the petitioner. Then, in the meantime, the said writ petition has been rendered infructuous since the collector, after all, decided the representation by the impugned order dated 16/11/2021. Excise Commissioner, right? By 16/11/2021. Paragraph. The court has perused the said order of the Excise Commissioner. Inter alia, it was noted that the collector Ganjam had on 15 September 2021 already granted the petitioner 1 month's time to shift his IMFL off shop to an unobjectionable site. Stop. Somehow this fact was not brought to the notice of the commissioner by the present petitioner. Full stop. In the circumstances, the Excise Commission noted that the appeal itself had been rendered infructuous. As open quotation, the appellant has himself accepted the shifting by virtue of his representation before the collector Ganjam, on which the collector Ganjam has extended a time period of 1 month for the appellant to shift his IMFL off shop to an unobjectionable site. Paragraph. This is virtually, therefore, the third writ petition by the petitioner for the very same relief. The court finds it not possible to accede to the submission and prayers of the petitioner that he should be allowed to continue at the present site at Mauza Patrakata under the Langleshwar GP. Full stop. The petitioner cannot be permitted to repeatedly raise the same issue, which appears to have been examined at length petition, which was disposed of in this court on 9 September 2021, recording the limited prayer of the petitioner made at that stage. In other words, it's not possible to take the issue to a stage where the petitioner's request to continue where he is at present should again be considered, should again be examined. Full stop. That stage is a long been crossed. Paragraph. In view of the orders already passed by this court, which require to be implemented in line implemented in compliance with the undertaking given by the petitioner himself to the court. It would be an abuse of the process of law to entertain further petitions at the instance of the petitioner. The writ petition is accordingly dismissed.
Grateful, Your Lordship.
My lord, the second writ petition 28141 of it can be taken on board, and what my lord is it is
All right,
infructuous
28141
of 2021.
Counsel,
It
the
is
petitioner states that taken on board, counsel the petitioner states that on account of the subsequent developments, this writ petition has been rendered infructuous. It is dismissed as such.
Grateful, Your Lordship.
Item number 7.
May it please, Milords. Milords, I appear on behalf of Mr. Shashwat Acharya. Milords, due to sudden medical emergency, he is unavailable today. So kindly keep this matter next week, anytime possible next week.
All right, 1 minute. Just the questions of law here.
Your Lordship.
Questions of law, page 24, my lord. I am appearing for the department.
So we'll admit and have the questions of law.
Question number A and B would be relevant.
All right. Admit the following questions of law are framed. Whether the tribunal was justified in upholding the enhancement of turnover of the petitioner by 10 times. Question mark. B. Whether the tribunal was justified in holding that, no, in upholding the findings of the first appellate authority regarding alleged suppression of purchase of iron ore and coal and sale suppression of sponge iron by the petitioner. You see the Mr. Padi accepts the full set of papers have to be served on you, or it's already there with you.
It has been served.
Mr. Padi states that the complete set of papers have already been served on him. The assessment record be requisitioned for the next date. List on.
My lord may call for the record from the tribunal.
All right. Record of the tribunal be requisitioned for the next date. List on 5th April 2022.
Your Lordship, this might require some interim orders. Can it be a shorter date?
What is the interim order you're looking for?
No coercive action regarding.
No, normally
the tribunal is remanded for remanded the matter.
Yeah, it's only a remand.
Oblige, Your Lordship. 5th April.
All right.
Oblige.
Same in the second. Both matters. Just 2 different years, that's all.
One is under OVAT and one is under OET.
All right.
Oblige, Your Lordship.
Orders item number 8. May I please, Lords?
May I please your lordship? This is regarding rehabilitation of the street.
My lord, in this matter, my lord, only today morning I was requested to appear. My lord, myself, P.K. Mahanti, senior advocate with Pranay Mahanti, advocate. My lord, what I find that on apprehension they have come, and whatever, my lord, for rehabilitation of the street vendors, that can be examined, that can be seen. But your lordship will find in paragraph 10, they have stated that there is apprehension, there will be expansion of national highway, whereas national highway is not a party. And there may be allotment for ITC hotel, and there will be acquisition. And this is far away. In the meanwhile, they have to be identified if at all they are vendors. But all these exercises has to be done, and they are about 30%. So that is
only
why
based on apprehensions, we record a statement that they'll follow the rule of law. Due process of law.
Yes,
Follow the
we
due
will follow
process
the-
before disturbing your current status.
We will follow the process of law, no doubt of. Have to respect to that.
All right, Mr. Manti, Learned Senior.
I'm for Bhubaneswar Development Authority of Orissa.
This court has heard the submissions of Mr. Jaina, Learned Counsel Petitioner, Mr. P. Manti, Learned Senior Counsel for the Bhubaneswar Municipal Corporation, and Mr. Dayananda Mahapatra, Learned Counsel appearing for the Bhubaneswar Development Authority. Paragraph. Mr. Manti states at the outset that the apprehensions expressed by these petitioners about being forcibly evicted is unfounded, and since there is no immediate plan of action in that regard, full stop. He states that in the event the petitioners are required to be shifted, the BMC will follow the due process of law and its standard operating procedure before proceeding with any such move. Paragraph. In view of the above assurance, Learned Counsel Petitioner states that he does not seek any further directions at this stage. The petition is disposed of.
Oblige.
My lord, here my prayer is something different. My prayer is to rehabilitation.
No, unless you remove, there's a question of rehabilitation.
No, they have placed on in a particular place which is not identified as rather they have identified
They have
a
said
place.
now, they've
Fine.
said now that they're not disturbing you, and if they plan to do that, it will be only by due process of law.
What I humbly submitted one line can be added, subject to your lordship's that annexure 4 land has been identified. These people have been assured. We have made a representation to rehabilitate. They have also issued. They have enumerated the list, my lord, and only they have to consider when and how to rehabilitate. That is only that. They have rehabilitated other street vendors in different areas. This
That will be considered. That will be considered, my lord.
Then my lord, representation should be considered.
That is what.
All right, Mr. Mohanty adds that the petitioner's representation dated 4th September 2021 will also be examined in accordance with law.
Oblige.
And after hearing the petitioners, an appropriate order, reasoned order will be passed thereon, not later than 7th March 2022.
Oblige.
All right. A copy of the said order will be provided to petitioners not later than 14th March 2022. All right.
I may be provided also a copy.
Yes.
Item number 10.
May I please your lordship? Despite my
What's the defect, sir?
representations,
There is a defect number 22. What is that?
I may be permitted one time to.
No, the on shop, off shop, what is this?
He has not implemented the license. He wants that this shop should not operate in a particular place.
We have represented,
So-
my lord. We have
So he should
represented to
include the
authority
license
concerned,
as a
No, you have to make him a
Sorry,
party.
my lord, we are on representation, my lord. We have represented to the authority concerned.
Sir, in this petition, if you want an order in your favor, in this petition,
My lord.
if you want an order in your favor, you have to implead parties who will be affected by such order.
In fact, my lord, we have no information regarding licensing, but shop is continuing in Noji.
Sir, it cannot be in a vacuum, sir. You have to make that effort, find out who the licensee is. You have to implead that licensee as a party.
I may be permitted one time, my lord.
No.
Within that period.
Counsel for the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition after making the licensee in question a party to the petition.
Item 11.
Oblige, my lord.
May please, Your Lordship. Lord, here the petitioner participated in the lottery and he submitted non-refundable earnest money deposit. Lord, he became unsuccessful. As per the clause of the statutory rules and orders of the government, that EMD should be refunded within 15 days. But I have represented before the collector under Annexure 5 on 2/8/21. But
What are
till
these
that-
defects, 6 and 14?
Lord,
What are the defects?
I don't know. Sorry, Lord, I'm not very fair.
You've got a copy, Mr. Monty, of this petition?
I've got.
Yes, I have.
And 6? Copy served, all right. The petitioner's representation dated
Under Annexure 5.
2nd August 2021 shall be examined by
Collector, Lord, Cuttack.
the collector, Cuttack, bracket Office Cuttack 3, and after hearing the petitioner, a reasoned order should be passed not later than 14th February 2022 and be communicated to the petitioner not later than 21st February 2022. The court clarifies it as not expressed anywhere in the matter.
Item 12.
Item 12, what are the number of defects? I will remove defects
Okay,
within.
list after removal.
Item number 13.
All are identical matters.
On a transport matter, transport matter.
Your Lordship may dispose the order by the next 3 my lords.
Yeah, same order.
But so far as the additional fee is concerned, judgment of this honorable court is covered. But here the petitioner.
Whom are you for, sir? Whom are you appearing for? Whom are you appearing for?
Transport department. For the transport department.
No, Mr. Pari?
Yes, I am for Union of India.
But here the petitioner has prayed for surrender of NOC. So once the NOC has been issued, it cannot be surrendered here again. But what the vehicle was initially registered at Jharsuguda. He has obtained the NOC to operate, to register in the region of Sambalpur. After 5 years, he has prayed for surrender of that NOC. So in order to delay in submitting NOC before the Sambalpur, RTO Sambalpur, there is delay and fee will be charged as per the notification. He prays surrender of NOC in RTO Jharsuguda. That is not permissible under the law.
My lord, surrender or submission, it is same thing, my lords. Your lordship go to the annexer, my lord, I have annex. That notification has been annexed, my lords. That is. Annexure 2, my lords. That is annexure 2. Your lordship may see, my lord, page 11, my lords. Page 12, my lords. That is column number 7, my lords. Change of residence. Half of the fee mentioned against serial number 4. Note. In case of a delay in submitting, no objection certificate or change of residence, an additional fee of rupees 5,300 of or delay of each month expiry thereof in case of motorcycle and 500 rupees for each month of a delay in case of the 4-wheeler, my lords. So wherever, anywhere I have obtained the NOC, I can either surrender in my main zone from where I have got it, or I can submit there, my lords, for which reason I have taken, my lords. So there is absolutely no difference, my lords. Anyway, I have to pay the, wherever I will surrender or submit, my lords, I have to pay the fine that has been struck down by this honorable court, my lords. So there is absolutely what is my learned friend is saying, my lord, is not correct, my lord. Submitting or surrendering anywhere. Suppose I have brought it from Orissa to Bangalore, from Bangalore to Orissa. So I have to submit anywhere, my lords. I can surrender.
Why should you shy away from paying that additional fee?
Additional fee, my lords, because of a delay, my lords.
No, why should you fight shy of paying that?
But that has not been submitted by either the party has not taken it, my lords. For that is why they are challenging, that they are imposing the fine, my lords.
No, I'm not able to understand what you see.
My lords, suppose I brought the NOC for last 5 years, I could not submit there, my lords. So there is a delay, my lords.
Delay can't be 5 years and 7 years, sir.
My lords, there is many times, my lords, suppose someone has, these are the private vehicles, my lords, it is not the commercial vehicles, my lords. So motorcycle and cars, this privately used, some people by mistake, they could not submit it, that is the point, my lords. Otherwise, these are not commercial vehicles, my
In the
lords.
next case, your lordship can see in the next case.
All my lords, submitting either way you can submit, my lords.
Lord, your lordship kindly see Annexure 1.
Yes.
This is the NOC. The vehicle was initially registered in the before the RTO Bhubaneswar 2. Lord, registered on Lord, in 2016, and the petitioner obtained the NOC to operate in the state of Rajasthan. So that NOC has been issued in the year 2000 to take back the vehicle to Rajasthan. Now, that NOC he wants to surrender here by saying that we have not taken the vehicle. That is not permissible under the.
Right.
So he has to take the vehicle to Rajasthan. Again, they have to obtain NOC from Rajasthan and again submit.
My lords, that is not the reason why I am satisfied, your lordship, because that is the law is very clear, my lords. If we suppose I brought the NOC from here, if I didn't submit, I can surrender here. Surrender and submission is the same thing, my lords. I will satisfy your lordship because this very clause is very clear, my lords.
No, different state.
Yes, sir, because I brought from Orissa, suppose my lords, I brought it from.
No, you got an NOC to operate in Rajasthan, right?
My lords.
Yes. So now you've shifted.
I have not submitted, no, I have not submitted there, my lords.
No, but having got the NOC, what did you do with it?
So I didn't brought the vehicle, man. Suppose I have not got the vehicle.
You simply decided, therefore, to keep quiet for 5 years.
That is because my lords, because it is not submitted, that is why fine, my lords.
It's not convincing at all, sir, what you are arguing.
My lords,
you got an NOC to operate in Rajasthan.
My lords.
You did not go to Rajasthan.
My lords.
So what did you do? You just kept quiet for 5 years.
No, that's why many private vehicles, what happened, my lords, they don't take it, my lords.
Then you surrendered back to NOC, right to the authority saying you don't want the NOC.
But I can submit here, my lords, because that is
you're choosing your own time. There's a whole thing. Nothing. One fine day you've decided, okay, I'll continue in Orissa itself. So I'll go back to the authorities here. He's saying it does not.
No, law doesn't. Law doesn't show.
No, he says you have to go to Rajasthan. You have to again surrender the license there, then get an NOC and come back to Orissa.
Well, that is not the law, my lords. I can submit here also. Yes, my lord, I will satisfy your lordship. Your lordship will keep it some other day.
No, why
that is law is very clear, my lords.
If it's so clear, show it to us today.
Well, let's tomorrow your lordship keep it tomorrow. I will show it because.
Certainly not. We're not joining it.
My lords, because
sorry.
But that has been.
Sorry, sir. You're a veteran in this field, right?
My lords, I
you filed hundreds of these petitions, correct?
Yes, my lord.
So you don't need any adjournment. You better show us the law. It's such a clear law. You say you show us the law.
I will satisfy tomorrow. You lordship at least keep it for tomorrow, my lord.
Certainly not, sir. Certainly not. We can pass it over. You bring back that very clear law. Bring it now.
My lord, I will satisfy yours tomorrow. You lordship please keep it because what my lord promises, I will clear it.
Simply dismiss it now. If you carry on like this, if you are not prepared to show us the law, we will simply dismiss the petition.
I will show your lordship.
Pass it over. This is the last time I'm telling you, Mr. Pani. We are prepared to pass it over to give you the chance to bring that law to show it to us. If you do not wish to do that, we will dismiss it here and now.
Your lordship, after lunch, my lords.
No lunch and all. We're just passing it over.
Just after lunch, my lords, I will see.
Mr. Pani, you heard me. Yes. Pass over.
Item 14.
My lord, I am filing an additional affidavit.
Mr. Pani, are you a designated senior advocate?
No, ma'am.
1 minute, sir. Are you a designated senior advocate?
No, ma'am.
Are you aware of the rules of the Bar Council of India? Are you aware, sir, of the rules of the Bar Council of India?
I have not gone through, my lords.
Mr. Pani, we find this reply to be completely unacceptable. How long have you been in the bar, sir?
More than 25 years, my lords.
And you are not aware of the rules of the Bar Council of India?
Sorry, my lords.
Are you aware of all the posters put in the Bar Association? Are you aware of the posters put up in the Bar Association? When we come back after the We do not want to see you wearing the senior gown. Yes.
Lordship, I am filing a additional affidavit. This is with regard to imposition of royalty on minerals. And in the meantime, the company structure has changed on the basis of the order of the NCLT. And so these areas have been taken into consideration in the
Just this bar, but anyone can wear any gown.
No, my lord, I'll just apply. In fact, what is being sold in the shops, they pick it. I don't side with any of them, but we will send across the message so that it's corrected in the next.
No, I spoke to the secretary myself. I was there in one of the rounds I was taking of the court. I happened to meet the secretary. This was last week or 10 days ago. And previous to that, for the last 1 month, you can ask Mr. Mudali.
Yes, ma'am.
I've been berating him actually. And then I spoke to the Advocate General. Then the Bar Council sent out a reminder. This morning he tells me there is messages put all over.
Yes, some of them might not be aware, but I think majority of them have rectified it. They have cut that.
No, today this is the third. I'm sorry. From morning, this is the third person. I refuse to entertain one of them saying that if you're falsely wearing a gown, I can't. You know the expression, we're not supposed to see you. You cannot be seen by the court if you're not properly attired. Some norm has to be followed here.
I apologize on behalf of the members.
So we are so proud of bar traditions and we have to respect those traditions. This can't be a tradition.
We'll rectify it.
Yes, yes. Sorry, we interjected from your submission. What were you saying?
On the issue that was being discussed.
Yes.
Some people think that if the tail is.
It is not, sir, not so simple at all, sir. It's not so.
They cut it and think that it becomes.
Does the client know about this elbow stretching of the gown? Everybody is looking at that flap on your shoulder, sir. Let's be clear on that.
Another fallacy is also around that a person who has put in 20 years of practice or 25 years of practice, even he is not designated, he writes that I am senior advocate.
That's what, there is only so much as a court we can do. I keep telling all of you,
I'm grateful.
This is all in your hands, sir. What kind of a bar you want to be?
Yes, I am indebted, Your Lordship, because of Your Lordship's looking into the decencies of this profession, which is in deterioration, condition of deterioration. Therefore, really, we also.
No, actually, you senior members are the only ones who can give the strong message.
That's true, madam. It's very difficult. But I'm not telling all those tales. But it's very difficult. There is no cohesion, there is no union, there is no nothing.
No, don't say no nothing. We know your elections, everything is happening, the whole body is elected.
My lord, elections have got threefold ways of things.
Whatever. Anyway, let's not get into that. At least let's ensure that this is
my lord,
properly followed.
I need a week's time affidavit with regard to certain developments and explaining that in the meantime, because of the merger of the company, a new entity coming.
So then you file a fresh petition. Let not keep
not a fresh petition, my lord. Not a fresh petition. Your lordship, here.
So this is a 2011 matter.
Yes. The subject matter is same royalty. But now that amount has been, my lord, merged because of the order of the NCLT. So therefore, it will be disposed of next day. Only my affidavit will be there on record. Your lordship will dispose it of on next day.
17/3/2011 order, my lord. Demand has been stayed.
Demand has been stayed. Demand, that means it is not the original amount. It is the interest on the minerals. I only need, my lord, 1 week time, 10 days time, whichever is convenient to your lordship. Or today I am filing. Your lordship may take day after tomorrow. Day after tomorrow, my lord. I want only my documents to go on record. That's all. I will not submit anything.
No, it's been adjourned twice and thrice.
No, my lord. I have not taken it. It was, I think some difficulty was there. It could not be taken up. My lord,
He's Mr. Mahapatra. Sir, you appeared on 9th August. You have the paper book, sir?
Yes.
Where is it?
No, not the paper book. It is
Have you seen the order dated 9th August? Just show him the paper. We'll help you, sir. We'll help you. It is our bounden duty to help the bar. With orders passed in your own matters.
Obliging.
All right, all right. Just see the order dated 9th August. You appeared, no, sir? Sir, it is your appearance, correct?
My lord.
Now turn, after this time you took time for instruction on 9th August. Then come to the next order, 13th September.
13th September. Yes.
You did not appear, but I'm sure Mr. Patnaik is your associate.
Yes.
And third, now come to 25th October.
Yes.
It is you who appeared.
Yes.
So 3 dates over already.
Yes, I have brought already on record the development, but I am filing the document, my lord. The documents of taking over the documents.
So we'll pass it over, you show us the documents. No more adjournments.
One day time. My lord, I have got some predicaments, my lord. One day time.
Sir, as a Chief Justice, I have too many predicaments.
No, my lord.
In a 2011 matter,
yeah,
I'm granting adjournment after adjournment, month after month.
I beg apology, your lordship. Kindly see this document I am filing today.
So just make a photocopy, we'll pass it over. Make a photocopy, make one more set for Justice Mahapatra.
My lord, it will take 3 hours time.
It will not, sir. It will not.
This is 100.
So, Katak photocopiers are very good, I'm told.
I know.
Yeah, yeah.
My lord, I beg.
They are excellent photocopiers in this very busy street.
I beg your lordship's apology. My lord, I have got certain difficulties. Let it be taken up tomorrow.
No.
Tomorrow, my lord.
No, sir. No, sir.
Tomorrow, my lord.
We'll pass it over. You bring it after a Passover. Sorry, sir. Sorry. Passover.
At 3 o'clock, my lord.
No time and all. Passover. Right.
Item 15.
My lord, yesterday I have filed certain compliance affidavit, hard copies today I am filing. Those are not in record.
Lordships, we have actually filed an interim report for all the 3 colonies, all the 3 visits. They are not there on record, but your lordship, there is some emergencies. If those reports can be called, they're there, your lordship, the scanning and everything was over.
Right.
The emergency, I think, will be reflected with Mr. Tripathi's photographs also.
All right.
So we insist to be taken up to
There are
that.
several photographs which we have annexed with our reports, my lord.
Right.
But this photograph this morning, we got it, so I thought it to bring to your lordship's notice, which is not there in the other reports.
My goodness. This is the same woman you had met.
No, your lordship, this is from
Jatni, my lord. This is from Jatni, my lord.
Okay.
In Jatni area, there are 4 patients, my lord, who requires immediate medical interventions, my lord.
All right.
And Baleswar also certain developments have taken place, so Mr. will be able to, my lord.
Why don't you give the copy of the photograph?
My lord, and I'm giving.
One way to do it, Mr. Mudli, you ask the collector Puri to be on video call. 2 o'clock.
Khurda, this is Khurda.
Collector Khurda or the CDMO Khurda, that's even better.
Both I will request.
2 o'clock. By then this will come.
Lordships.
All right.
Let the reports be called for from the register.
And these are also a soft copy of all the videos we purposely carried so that won't get missed.
All right. All right.
This is of course confined to Puri, but
So that reports you called for, what we filed, the interim report. All right, 2 o'clock. Yeah.
Item 16.
May I please yours? The last occasion, we have filed the date short submission because that was the requirement of the honorable previous bench. If you also look at on 24/9/2021 of file, it's a case regarding denial of promotion to the petitioner to the post of senior secretary in this honorable court's establishment. 23/9/2020.
We'll do one thing, sir. This will take some time, correct?
Well,
this will take some time.
Yes, sir.
So we'll keep it at the end of the board. Right. Let's go through the list.
Item 17.
May I please, my lord?
Yes.
My lord, this is a writ petition in related to PS purpose, my lord. The present petitioners, Young Sean, my
2020. That will be the date of notice, 15 days gap. And that's why they are here, my lord, the full court judgment, my lord, has been misinterpreted by this way. And that's why my respectful submission. So I want to draw lordship attention, my lord, page.
The lordship on the last
30.
petition had asked the state to produce all the records related to this matter, your lordship.
Correct.
A few weeks' time may be given, your lordship. We've intimated them. Maybe a week's time, your lordship, so we'll get the records.
All right.
Madam, madam, I don't know who's for appearing. State. My lord, my respectful submission, the Sarpanch has been unseated.
Sir, we need the record. In fact, that record might stop all arguments and maybe it is in your favor. Once we get the record.
The record, all the my lord, the record is with him at the letter, man, the WPG my lord. There is no more record is required because the point of law, whether the date of putting the,
you don't need the original
date of notice.
You don't need the original record.
No.
In the Sarpanch's office, on date of dispatch, you don't need all that record.
That's why, my lord.
As a writ court, we need that record. So you may not read that, but we are a writ court, we need that record.
That's true, my lord.
You may not need it.
Let me
Normally,
my lord.
in a writ court, when you go for a certiorari, the very term certiorari itself is called for the record.
That's
So the
true, my
record
lord.
is very important, sir.
That's true, my lord. My lord, my predicament, my lord. The Sarpanch will be completed 2022 and he has been unseated.
Sir, the only question we will ask is, do we list it for 9th December or 16th December? That's all. Maybe 8th December or 15th December.
Date.
15th,
All right. 15th December.
Ms. Suman Patnaik assures the court that on the next date, the records shall be kept ready for its perusal. At her request, list on 15th December 2021. All right.
Item 19. May I only think, submit my lord. As a last chance, they will not take adjourn.
No, they will not.
Because they are in advantage.
You say as a last chance. Correct.
Item 19.
This petition is filed for vacation of acquired land property of the petitioner, my lord. The case is that opposite party has acquired the petition giving compensation. I have been going through the authorities since 5 years before opposite party number 2 and opposite party number 1, and also filed several writ petition, my lord. Last writ petition was disposed of by this honorable court by Annexure 10 series, page 38, my lord. Kindly see page 38, my lord. Page 38, direct to appear before the commissioner Sundargarh for giving compensation. Kindly see page 38, my lord. The control steps said authority disperse the such compensation after the commissioner, the eventually complete within 3 months. For conveyance the parties, we direct the parties to appear before commissioner at Sundargarh in his next sitting at Sundargarh. From the date said that the commissioner will conclude the proceeding within a period of 3 months. Thereafter, Commissioner Sundargarh said that I have no jurisdiction. Thereafter, I have filed the miss case. Again, this honorable court modified the order, page 42, my lord. Page 42, direct to appear before the Commissioner Bhubaneswar, my lord.
Yes.
Got your lordship. Thereafter, I have filed the civil case number bearing 79 of 2020, page 43, my lord. 9/7/2020. Then again, Bhubaneswar Commissioner said that I have no jurisdiction. Thereafter, I have filed this case for vacation of the official land because of due to non-payment of compensation, my lord. Till that, I have been possession, my lord. My rejoinder, annexure, my lord, annexure 13, my lord. This is the demarcation order of the Tahsildar, my lord.
Where is the order of the Bhubaneswar Commissioner?
Bhubaneswar is not taking any step, only.
Lordship, I am appealing for the opposite pattern of two Millers. Millers, in view of the Mathia Swaram case, Millers, Supreme Court has only given a 14 village to adjudicate the matter. If the commission is constituted in view of the Supreme Court order, I have annexed that order, Millers. Lordship, Sundargarh Commission and Bhubaneswar Commission is the same commission, Millers. He has only camp court at Sundargarh, Millers. So that's why Honorable Commission has said that I have no jurisdiction to decide the matter because the Lordship see the order, Millers. I have annexed that order, Millers, annex of H/2, page 37, running page 137, Millers. At page, Millers, paragraph 22, at page, let's see, at page, Millers, 145, para 9, Millers. Internal page 95, Millers. Millers, got it, Millers.
So the 14 villages are there.
Yes, Millers. Only Millers under the Himagiri Tahsil, Millers, that is 14 villages have to be adjudicated by the only commission, Millers.
What about the rest? What happens to the other villages?
Rest Millers, that is under CBA coal bearing tribunal is there and it is land action collector is there, Millers. Millers, here is a case, Millers. It's a government land, Millers. Acquired, Millers, person to Millers 10/82. I have made a proposal request to the government authority to alienate the government land for the mining purpose. Millers, your Lordship, see Annexure A/2, 74, page 74, Millers.
Yes.
Page 74, running page 74, Millers.
Yes.
Millers, this is bring to your kind notice that 2 million of ton open cast coal mining project is shortly going to be started near village Dallipari, Challa, Kisma, Bandabal. Bandabal is the village of the petitioner, Millers. Ubunda and Krishna Loi, Millers. The project will have to life of 30 years and further provided to coal is in progress and notification SO number such and such dated such and such, Millers, has already been issued under section 9 of the Coal Bearing Act 97, acquiring the mining rights in a total area 5.248 acres, which has been vested with the Western Coalfield, now MCL Millers, Coalfield Limited, Millers. Lordship, second para, Lordship, see second para. In order to start mining activities in the above area, as well as the start the work, infrastructure facilities like railway, sliding, etc., need 1942.870 acres of government land in the above 6 villages.
No, so 1 minute. So after this letter, this land was alienated in your favor?
Yes, Millers. Yes, Millers.
No, but you obviously did not. You only took constructive possession. You did not take physical possession.
Millers, physical possession has been delivered, Millers. Advanced possession has been delivered, Millers. Your Lordship, see Annexure D/2.
I see.
Yes, Millers. Page
1983 itself.
Yes, Millers. And thereafter, I have also deposited premium, Millers, 9 crores something, Millers, with the government authorities, Millers.
No. So these people were occupants of this land?
No, Millers. Advance possession has been given to me and
not adverse possession, sir.
Advance possession, not adverse possession, Millers.
Actual possession.
Possession has been delivered to me, Millers.
No. So these people were all occupying that land, or what? How do they come in? The present petitioners.
Millers, he said that he was a lease prior to the settlement, Millers. 76 settlement. In 76 settlement, it was a government land, Millers. They have not before any challenge before any authority that my land has been not been settled in favor of me, and it was a government land. There is no challenge, Millers.
So so they have no title or interest.
Exactly, Millers. Thereafter, Millers is filed a writ petition without adding the party to the MCL, Millers, and take a ex parte orders, Millers, that this honorable court direct to the collectors Sundargarh to issue a photo, Millers. Accordingly, Potas issued. Lordship, see that, Millers, I have deposited 9 crores something, Millers. If Millers he has entitled to get, Millers, collector will give that amounts, Millers. Because I have already deposited, Millers, with the collectors. Lordship, see Annexure E/2, page 85, internal page 36. Lordship, total is 9 crore 60 lakhs 69,666. I have deposited, my lord. For my lord, your lordship, see Bandaval, Khata number 104, plot number 69. In fact, plot number 69 is the half plot
No,
number
but if it is
69.
government land, then they can't get compensation.
Yes, your lordship. And so far as commission is concerned, Miller's commission, in fact, there is no jurisdiction to decide the matter because in view of the Supreme Court judgment, Matthias-Swaram case.
Yes, yes, please.
My lord, kindly see page 13, my lord. I have stated the petition, father of the petitioner filed the WKS number 405 of 1974, 13 page, second para, my lord. Initiate the application filed by the father of the petitioner, then the law said the plot number this is favor of the father. Therefore,
No, it is a
the
contention, sir. That is simply a contention.
My lord.
So there is no finding. In fact, it records, just come to the bottom of page 13. Page 13, bottom. 1-3, page 1-3, come to the bottom.
My lord.
Law is well settled.
Law is well settled. Otherwise, neither create any title nor entry same. Apparently, lease granted favor of the father petitioner WKS number 405 of 1970 still substituting.
It's not actually not correct then, because this is actually government land.
No, my lord. In a settlement, there is no wrongly reflected the land of the father of the petitioner, my lord.
But in a writ petition, you cannot get all this relief, sir.
My
You
lord.
have to file a suit or whatever to declare your title, first of all.
Thereafter, till that I am paying the government fee, my lord.
What fee?
Government fee of the land, my lord. Annex 12 of my miscase, my lord, 6316 of 2021. I am paying the government fee till date, my lord. This is the last received, my lord. 2021. And also demarcation.
Which page are you talking about?
IN number 6316 of 2021, Annex 12, my lord.
Yes.
This is the government fee paying in the aforesaid land in favor of the petitioner, my lord. This is the last received, my lord, 2021. And recently, demarcation order of the Tahsildar, my lord, my rejoinder, Annex 13, rejoinder, my lord.
Then you are continuing this land?
My lord.
So why do you want compensation then?
My lord, only
why do you want compensation? You are continuing with the land.
My lord.
So what do you want compensation for?
Lord, dispose in this matter, in this regard.
Your lordship, your lordship, your lordship, see 152 page 5152 demarcation order. Lord, this case is taken up today. The petitioner is present. The boundary tenants are present absent, and the bound tenants are present absent.
You are MCL. You are MCL. If you want to take remedy against this order, you go ahead. Right now, he's sitting pretty. He's paying
the government has given to me and alienation. That is my land.
Anyway, he has disclosed to you this order in his favor. It's for you to do something.
That order which you have not challenged, previous writ.
Yes, yes.
He stated that case is pending, Millers. Therefore, demarcation into 2021 during pendency
of the direction that opposite party number 2, Mahanadi Coalfields Limited, should open quotation vacate the petitioner's land, measuring an area of AC 2.00 DEC, Sabik Khata number 32, Sabik plot number 107 by 5, situated in Moza, Bandabal, in the district of Jharsuguda, within a stipulated period. Full stop, unquote. When MCL filed a counter affidavit stating that the land in question was in fact government land which stood alienated in favor of MCL, the petitioner filed an IA 6316 of 2021, filed a rejoinder, enclosing order passed in demarcation case number 147 of 2021, which in turn was pursuant to an order passed with this court. Where is the order of this court? On 12, passed on
page 43. Page 38, my lord. 38, my lord.
Let's go 12-9.
No, regarding demarcation.
No case, no order has been passed. During sentencing of the case, they have
Remove the last part. Demarcation order.
Without
in
making
demarcation
practice.
case number 147 of 2021. Apart from this, the petitioner has also filed IA number 6316 of 2021. Stating that the petitioner is being paying the cost of government fees even till 2020-2021. Paragraph counsel the petitioner maintains that the petitioner is still in possession of the lands in question and he is continuing to pay the dues. Paragraph, in view of the above statement, the court sees no reason to grant the relief that is prayed for in the petition, since that is contrary to the factual situation on the ground. Therefore, without expressing any further view on the contentions of the parties, the court disposes of the writ petition.
Lord, it's affect my mining rate, my lords, because I am
Yeah,
in possession.
as far as MCL is concerned, it will be open to the MCL to seek appropriate remedy vis-a-vis the aforementioned orders mentioned in separate proceedings.
Item 20.
May I please? When the petitioner has challenged the order of the appellate authority, and lordship, due to a defective tender and which has been confirmed by the appellate authority, the order of the Tahsildar. Lordship, kindly state I come to the order of the Tahsildar comparative statement first, lordship, at running page 26, lordship. The petitioner has participated for the particular source list which appears at serial number 4, that is Ghata Kaintara Bali Khadal Shansairat. Lordship, running page 26, lordship, they have made a comparative statement, lordship. 5 bidders had participated in the bid. That is running page 26, lordship.
Yes.
My name finds serial number 5, lordship.
Right.
And I have quoted what is additional charge of 696. I was the admittedly highest bidder, lordship.
Right.
And out of 5 bidders, they have rejected almost 4 bidders, lordship. They have allowed only 1 bidder, that is serial number 2, who has quoted only 282, lordship. And they have rejected my bid on the ground that I have not quoted the solvent certificate, not given as per the mining rules, lordship. They are not saying as per the obtaining condition. Now they are saying, my lord, as per the mining rules, I have not quoted the condition. Then lordship kindly show the advertised condition. And my humble submission, I had participated in the tender process in consonance with the terms and conditions fixed under the advertisement. Lordship kindly state I come to the advertising condition, my lord. Lordship, I have. It starts from running page 20, lordship, English translation copy I have annexed. Just I will point out, lordship, only 3 to 4 lines, lordship, of the running page 20, just I am English translation copy. First paragraph, only last line I am reading, lordship. And highest bidder will be awarded the contract. Incomplete applications will not be accepted, lordship. These are the terms of contract. Then will lordship kindly come to state next page 21, clause 6. They have rejected on this ground, lordship. Submission, bank guarantee or solvent certificate more than royalty and additional charges of minimum guarantee quantity to be excavated in a year. They have given equation, lordship. This is very important. MGQ multiplying the royalty plus additional charges, lordship. Lordship kindly state I come to next page that the figure is there on page 22, lordship. And I have participated serial number 4, lordship. 4. Ghata Kaintara Shansairat, lordship. The royalty they have quoted rupees 35, lordship, rupees 35. And additional charges 2 rupees. And lordship, they have given the MGQ that is 10,000, lordship. So as per this calculation, lordship kindly account my rate application, I have quoted, given the figure in a particular paragraph. that is running page 40 lordship, is running page 9. It comes with 3,70,000 lordship, that is. And I have given this figure, lordship. As per terms of contract, as per the terms of advertisement, I have given the Miller solvent certificate, but the Tahsildar has rejected my application. On the ground that it appears to run page 27. It refills from the lordship, I'm reading the press 27 lordship.
Yes.
It refills from the comparison statements, Annex A. See, Narottam Mahanti of Bhubaneswar has quoted bidding rate of rupees 696. Accordingly, he has to submit solvency for rupees of 7 crores 31 lakhs. But he has submitted less value solvency of rupees such and such period. As per rate offered by him, is not accepted, lordship. By this way, they have accepted a single tender, and only they have accepted only 200 some rupees, lordship, and they have rejected my bid. But this is the provision, my lord. I am quite out of the provision. It is the provision under the mining rules, lordship. I am just coming to mining rules, lordship, rule 27, lordship.
Yes.
27 Miller, that is 27/4 Miller, Roman 4 Miller. That is.
This is the 2004 or 2016?
2016 lordship, 2016. I mean, 2016 lordship.
A solvency certificate.
A solvency certificate or bank guarantee valid for a period of 18 months for an amount not less than the amount of additional charges offered. Well, this is important. And the royalty payable for the minimum guaranteed quantity for 1 whole year, and a list of human properties for revenue authorities, Miller. But here the offered amount is their lordship. Admittedly, Miller, rule says we have to get the solvency certificate as per the offered amount. But the advertisement condition says, Miller, is something different, Miller. The offered amount is not reflecting the advertisement conditions, Miller. That's why a confusion took place. And Miller, as per the terms of advertisement, I have quoted the offer, lordship. I have given the solvency certificate. Then, lordship, can you see clause 9 and 10 also? That is also very important. Clause 9 and 10. In the event of default by the selected bidder, the competent authority must issue intimation as specified rule 6 to the next highest bidder, who shall then be required to convey his acceptance and to make the security deposit calculated in the manner mentioned in sub-rule 7. Then the second highest bidder has quoted unusual low price in comparison to the highest bidder of the same source of the other sources in the vicinity. The competent authority may bring to into notice of the controlling authority, who after proper verification and with due justification may cancel the bid and direct for fresh action. Miller, two things appear from the Miller. The legislative intent says, Miller, only to raise revenue. Miller, this clause is there, and so Miller, the rule itself speaks. The second bidder must be there. It is Miller the mandate of these rules. The second bidder must be there. But here, Miller, what they have done, let's kindly see. Miller, there is no second bidder. Miller, again, 1 second, I'm trying.
Yes, carry on.
Lordship. 1 second, I'm trying to draw your lordship's kind attention to page 26, lordship.
Yes.
I have quoted 696, almost 700 rupees Miller additional charges, lordship. Miller, they have considered.
The only point against you is the solvency certificate.
Solvency certificate, Miller, I have quoted as per the terms of advertisement. Miller,
Let them reply to that.
Sorry, lordship.
My reply, lordship, may kindly see the counter affidavit of the sub-collector.
Correct.
Paragraph 14, internal page 5. Sub-collectors counter affidavit.
Oh.
The deponent is Nihar Ranjan Kaur.
Correct.
At present working as sub-collector Sonpur.
Yeah, in reply to arguments made in para 10.
In para 10 of the reply, it is humbly submitted that Rule 2744 of OMMC rules states that a solvency certificate or bank guarantee valid for a period of 18 months for an amount not less than the amount of additional charges offered and the royalty payable for the minimum guaranteed quantity for one whole year, and a list of immovable properties from the Revenue Authority. The opinion of 4, Tahsildar Torba had published the advertisement for auction. No, my lord, para 15, I'm sorry. And in reply to the averments made in so and so, it is only submitted at 0.5 Saraj Sir Torba Tahsil issued by letter number so states that along with applicant, the applicant has to deposit the EMD amount, which is 5% of the MGQ into royalty plus additional charges, which is to be paid as bank draft to the Tahsildar Torba payable at Darpa at the bank and the bank guarantee or solvency certificate should be higher than the annual value of the Swaraj source, that is MGQ into royalty plus additional charges. The calculation done, the crux of the matter is the calculation. The calculation done by the petitioner for the solvency amount is wrong, since the amount of MGQ into bracketed royalty plus additional charges should be as per the rate quoted or offered by the petitioner, that is 10,000 into 35 plus 696. 696 is the additional charges, is equal to so and so. Instead of 10,000 into 35 plus 2, that is 37, as contended by the petitioner. Hence, the plea of the petitioner that he has submitted the required amount of solvency. We have justified that how the solvency certificate submitted by the petitioner was inadequate. He has not followed the proper calculation. Calculation is royalty plus additional charge, MGQ into royalty plus additional charges. And it comes to 73 lakhs, 10,000.
Whereas he's given for 37 lakhs. No, he's given it for 3,70,000. He has given it for 3,70,000,
Yes.
whereas it should be for 73 lakhs 10,000.
Yes, madam.
Rule provides for lordship. I for lordship, but kindly have a glance to the advertising condition.
No.
Well, condition,
advertisement cannot-
they cannot alter the terms of advertisement after cut off that lordship.
No, it has to be subject to the rules. The advertisement also has to be follow the rules.
Lordship, that is my case also, lordship.
Yes.
So my humble submission for lordship,
Yes.
the entire advertisement is defective. Well, I cannot travel beyond the advertising conditions, lordship. Well, I have to participate in the tender condition, tender in view of the terms of the advertisement. Well, lordship kindly see on page 21. Well, they are not saying additional charge. They are saying lordship kindly see page 21. They are saying will not the price, will not additional amount as available on the terms of contract. So, I have applied.
You have to follow the rules, please.
Rules there, rules I have never. I don't dispute the rules, lordship. Lordship, kindly see.
Page 21.
The advertised conditions cannot be contrary to the rules. If they have floated it,
Just come to rule.
There is no contrary.
that is contrary, lordship.
How can you say so?
Yes, I have demonstrated, I have reflected, and Miller can see the page 21.
Royalty plus additional charge, and that's what I think he's also referring to.
Page 21, lordship, I have given the translation copy. Miller, the advertised condition speaks. They are not saying the offered amount. They are saying the additional charge, which has been quoted in the terms of contract. The additional charge is 2 rupees, lordship. 35 plus 2 into MGQ. That is the calculation as your advertisement speaks of.
A typical submission.
Not typical submission. You are making a typical submission.
Additional charge you have stated.
Very unfortunate submission. Don't make it
One minute.
Listen, what sort of loud voice he is making? Whether state is dominating to the consumers?
Mr. Dalai, will you let us speak or will you go on speaking?
Lordship, because they are making very objectionable statement, Lordship. And the submission, the mode of submission is very unacceptable, Lordship. We are working in the same field, Lordship, but the submission must be very.
All right. Yes.
My lord, my resolution submission is that rule provides that additional charges in the writ petition. He has offered that I have offered additional charges is 696. So how can he say that it is 2 rupees? It is unusual. It is typical. That is what I am submitting. He has himself offered in the writ petition that I have offered additional charges of 696. So far as the second
come to page 22 for a moment, Lordship.
So far as his
The terms of contract says, Miller, 2 rupees is the additional charges, Lordship, can see page 22. That is the terms of advertisement.
And what about?
I am confused, Lordship. I am not, Lordship, page 22, Lordship, kindly see. Page 22. This is their advertisement.
No, the advertisement and what is stated in the internal page 7,
Lordship.
running page 49,
7, Lordship, I'm coming.
is the same.
Lordship, I'm coming, Lordship. Lordship, referring to advertisement, Lordship.
No.
Sorry, their counter, Lordship.
That's right.
Lordship.
Collectors, internal page 7.
7, I have got, Lordship.
So the formula given there,
Lordship.
MGQ into royalty plus additional charge
additional charges.
is identical to what is there in the advertisement.
No, no, Lordship, no. Lordship,
Yes,
can page 22, Lordship, kindly see.
Yes, yes.
Lordship,
Clause 6 of page 22.
Lordship, Lordship.
Page 21, clause 6.
Lordship.
Yes.
MGQ royalty plus additional charges.
Correct.
Then
That's
Lordship,
exactly what the.
no, page 22, that is my offered amount, Lordship. Page 22, Lordship, kindly see. This is their advertisement. Page 22, Lordship. Column number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, Lordship, 9. Additional charges. Additional charges, Miller, they have given 2 rupees. Miller, 696 is mine. I have offered them 696. But Lordship, they have floated with the tender notice. The additional charge is 2 rupees. Listen, this is the confusion. Statute says, Lordship, you have to give the solvent certificate as per the offered amount. The advertised conditions must have been the offered amount. The additional charge offered amount.
All right. All right. Anyway.
Lordship, that is confusion. Enter confusion, Miller. That is the confusion, Miller, with the tender, Lordship.
All right. All right. The petition is dismissed. We pass it to you.
Lordship, once again, another 2 points, Lordship. Lordship, once again, Lordship, perhaps I am not unable to convince you, Lordship. Lordship, once again, I am just making one line submission, Lordship. Can bear with me, Lordship. Because Lordship, kindly see, the advertisement conditions cannot be compared to the rules. I have to participate in view of the terms of advertisement, Lordship. They have given a figure in advertisement. This is the royalty amount, and this is the additional charges. And you have to submit a solvent certificate with a certain calculation. They have given calculation, the MGQ multiplying into the royalty plus additional charge. With the additional charge, they have given a figure of 2 rupees. Then, and Lordship kindly see the royalty also given in the advertisement conditions. Lordship kindly for Lordship for
you're just repeating yourself.
Not repeating, Lordship.
All these points you just now argued, you're repeating the same thing.
Lordship, Annex 3 for movement, Lordship. Annex 3 for running plus 30. This is the continuous practice of the lower officers, Lordship. Annex 3. I have participated same contract before same Tahsildar, and which have been given just 2 months, Lordship, can say Annex 3 for movement, that is 22/6/2020, Lordship. After completion, Lordship, it is informed that to me, Lordship, you have been selected as the highest bidder for the double stone quarry for 5 years lease. According to notification, you have guarantee of rupees 5,60,000. On scrutiny, it is found that you have quoted 190 per cubic meter for additional charges. As such, the amount bank guarantee of rupees such and such. Hence, now you have instructed to submit the differential bank guarantee in that office within 7 days. Otherwise, your bidding shall cancel with the. So, it is the usual floating style. But if I come selected as the highest bidder, then it is duty of the authority to give me second notice. Here, Miller, without doing so, Miller, by floating here, Miller, defective tender, now Miller, they have direct cancel. And Lordship, kindly see the rule 9 and 10. There must be 2 bidder. They cannot give select a person, single bidder, who is quoted a very low price. Lordship, kindly see, but the entire legislative intervention says, Lordship, through raise revenue. The Tahsildar cannot act on his own way without approval of the higher authority. He will give a person who is quoted only 282 rupees, Lordship. So, if for a defective tender, law says the authorities cannot change, alter the tender conditions. And I will abide by the terms of advertisement, not rules, Miller. Because they have come up with a particular manner, and in that manner, I have participated in the tender process. So, they have done it, Miller, illegally by putting a wrong process, and they have selected single, my second ground, Miller, they have given it to a single bidder. That is not permissible under the statute. And the third point, Lordship, kindly say what prompted me to allow my bid. They have selected my bid, they have disclosed my bid, and then Miller, with a subsequent step, they are saying, no, you are not eligible. Miller, numbers of judgments, Lordship, are given. Once you have disclosed my price and you accept my bid, and subsequently you cannot cancel my bid.
Yes. All right. All right. Next time.
This is also.
Yeah. lawyers, one senior lawyer and 2 lawyers who are assisting the court as amicus curiae, and they colonies and giving us reports. So they've handed over one report to us today, and the situation seems pretty dire in both these colonies. So what I'm requesting is that the government council will transmit to you the copy of the report with the photographs. Among the things that we want immediate attention is this case of one of the inmates. I don't know if it can be sent to him by a WhatsApp or.
Yes, I have already given.
So you have seen that, sir, Mr. Mahapatra?
Yes, sir. I have got in WhatsApp, sir.
And the DPMU is also with us. He's the medical CDMO.
Yes, sir. He has joined, sir.
Sir, can you tell us if this can be attended to immediately?
Sir, already, I think he is not switched on, but I have called the report because Honorable CJS.
I think he has to just unmute. You just tell him to unmute. Doctor, I don't know his name.
Sir, Dr. Pati, I'm just telling him. Sir.
Dr. Pati? You have to just unmute, sir. Yes. Now you can speak, Dr. Pati.
Sir, namaskar.
Namaskar.
Sir, I'm here, sir.
Yes. So what you diagnose this as, sir? What is your diagnosis?
Sir, these 4 cases I'm telling. Sir, sir, you are telling regarding the gangrene part of somebody. Lakshmi Maharana. Lakshmi Maharana, 61 years.
Correct.
It is a case of ulcer foot. It's not actually gangrene. Local gangrene for which ulcer has occurred.
Okay.
And with severe anemia.
Okay.
She's been treated regularly by our medical officers, and present just because of anemia, we are referring the patient to AIMS.
Okay.
The patient will probably move to AIMS within a short period.
Short meaning today, sir?
Within 2 days, sir. Within 2 days, sir. Sir.
All right. What about the other 3, sir?
Sir, other 3, Santosh Kumar Das. She's a case of renal failure, sir. Both the kidneys have failed. So, with severe anemia, she is already she has gone to AIMS. Already referred.
This all happened, my lord, 2-3 days back when I visited the court. Have witnessed. Maybe within I don't know just now if this information is coming.
She was already referred.
Today.
So
I don't have that.
All right. Sir, do you have a doctor regularly visiting these colonies?
Sir, once a week we are regularly visiting. We are visiting regularly once a week, sir.
One more aspect, my lord, may I bring to your lordship's notice, my lord? Lordship, these leprosy patients, my lord, they don't have any Aadhaar card because they don't have the hands and the vision, my lord.
Correct.
So therefore, I am bringing to your lordship's notice, and I will implore upon the collector Khurda, my lord, to kindly take care of that situation so that
I think there is a protocol for that also.
My lord.
There is a protocol elsewhere.
My lord.
Mr. Mahapatra, can you unmute and yes.
Sir, I have already discussed with our center, sir, one-stop center, which is doing it. Sir, iris scanner, we will do it. Sir, in the next week we are planning, and hopefully, sir, it will be done.
Because I think you can take your equipment to the colonies and get it done there itself.
Yes, sir. Yes, sir. Already I have made a plan, sir. In this week, actually, our team will go there through iris scanner, and we will do that.
So there is something called the MCR footwear. You're probably aware of it. For inmates of these colonies, they're supposed to be supplied, and this is because of the Supreme Court judgment. They're supposed to be supplied footwear of grade 1 and grade 2 have got the grade 1 footwear, but they have not been supplied grade 2 footwear.
That we have filed the affidavit to that, you know, paragraph 4.
What do we say?
Stated in detail. Now, there are 13 numbers of leprosy cured persons at Dharavati leprosy colony.
Right.
Out of the total cured leprosy persons of 13 numbers, 1 number belongs to grade 1 category and 12 number belongs to grade 2 category.
Right.
MCR footwear of grade 1 have been supplied to 1 number of cured leprosy person, whereas MCR footwear of grade 2 have been supplied to 12 numbers of cured leprosy persons. Similarly, there are 11 numbers of leprosy cured persons at Bapuji leprosy colony.
That flagged as the removal of garbage.
That also we have stated in paragraph 5.
See, the sanitation workers have to regularly visit. It has to be on a daily basis. It can't be a weekly basis.
We have stated that the executive officer Jatni municipality by letter number 200 dated 11/11/2020 collector Khurda regarding cleaning of drainage and sanitation thereof in Bapuji leprosy colony and Dharavati leprosy colony. The executive officer also submitted the photographs in support of the said fact. The open drains in the above mentioned two leprosy colonies are regularly cleaned by the staff deployed.
No, but look at the photographs now, enclosed with this. So the open drains.
May I also bring to your lordship's notice, as per your lordship's last order, my lord, as per your lordship's last order, my lord, the additional toilets. Lordship, may kindly see the toilets condition now.
Yeah.
And there is no additional toilet, my lord, till date.
Right.
In that area.
Yes.
And in their affidavits, my lord, they have taken a plea that the toilets, they are going to do that. And lordship, may kindly see, my lord, page 18. No, my lord, this is what is. This is in page 17, my lord. 17 of the affidavit, what is being filed by, my lord, the CDMO, my lord, of the Khurda.
Dr. Vishwaranjan Putri.
Right.
Page 17 may kindly be seen, my lord.
Yes.
In response to this is a order of 26/11/2021, my lord.
Right.
In response to compliance letter on dated so and so relating to CLP College, Jatni Municipality, Bapuji Colony, Dharavati Colony in ward number 22, the construction of toilets will be completed within a period of 2 months under Mukta program. They have not yet started it. So these photographs I had shown, my lord.
Toilet construction, Mr. Mahapatra. Toilet constructions can take place within 2 days and 3 days, if I'm not mistaken.
Sir, day after tomorrow it is being started. Sir, it is being constructed under Mukta scheme. Sir, we have got the approval from the government, sir, just 4 days ago. Okay. So there 4 toilets are existing. So another 6-seater toilets, sir, we are going under Mukta scheme. Sir, day after tomorrow, sir, it will start and we will try to complete it within 1 month, sir.
All right. So if the team of lawyers visits these colonies last week of December, everything will be done, sir?
Sir, definitely. Sir, one issue would be there, sir, because it is, sir, now I just come to know, sir, it's a railways land. The road person and other, whenever our municipality staffs are going, the RPF and railway staffs are regularly making some sort of problem there. So so that's why the executive officer has requested me today that we need to have the meeting with the railways. So that the railways may allow them also.
Sir, may I make a small point?
Yes, Mr. Parija.
If your lordships could in the order say that the railway authorities will not stop people from going to cleaning the place, I think that would suffice. These meetings will end up in no solution. Your lordship may only say that the people who are going to clean the place, sanitize the place, their egress and ingress should be permitted by the railway authority.
All right.
And Mr. Mahapatra, our Chief Justice is very clear about timelines. So you have said end December, you make sure you do it by 20th of December.
Correct.
Sir, definitely will do. Sir, another issue that I was telling about the road. There is also a photograph of road that the railways were not allowing that. That was what I highlighted.
In fact, there was a direction for the collector and the state government to look into the land issues.
Right.
Because these colonies are on all encroached land.
Right.
So that also has to be resolved for longer term.
Correct.
The direction is already there in place.
Should we get the railways in, Mr. Mahapatra?
Yes, I think it will be good. Because I think that's what the law commission also said all over.
We'll ask the railways to participate in the hearing. We'll issue a notice to them. Then this can be sorted out.
My lord, in the meanwhile, no harm in your lordship saying that railway will only permit people to go clean and come back. That should not be a problem.
We'll do that.
There's the second report also. Every colony has a separate
report, is it? We've got this Khurda report now.
The second report is Puri, your lordships. Just to give a brief background, actually, a lordship.
So let me just dictate the
Lordship,
Khurda
that
part.
will-
Right. The court has been handed over a field visit report of the Makis Curie, Mr. Gautam Mishra, Senior Advocate, Mr. Biphu Prasad Tripathi, Advocate, and Ms. Pamirat, Advocate, on the condition in the two colonies in Jatni, that is the Dharavati Leprosy Colony and the Bapuji Leprosy Colony. Stop. The court has also perused the compliance affidavit filed by the CDM and PHO Khurda pursuant to the order passed with this court on 2nd September 2021. Paragraph. The hearing, which took place today at 2 p.m., had the participation of Mr. Mahapatra, the collector, Khurda, and Dr. Pati, the CDM and PHO, Khurda. The inmates who require immediate medical attention, that the situation of inmates, 4 inmates who required immediate medical intervention was discussed. And the court has been assured that one of them, who has an ulcerous foot, will be shifted by an ambulance today itself to AIIMS Bhubaneswar for treatment. The other 3 inmates, the court was assured, are receiving prompt medical attention as is required. Paragraph. On the supply of MCR footwear, the court has been informed that while MCR grade 1 footwear has been supplied to the cured leprosy persons, MCR footwear of grade 2 have been supplied to most of the cured persons. And those that have been left out will be provided such footwear within 7 days from today. The photographs of distribution of such footwear have been enclosed with the compliance affidavit. Issue of garbage removal, cleanliness, the court is assured by the collector that sanitation workers have been asked to regularly visit. Do they visit every day, sir, Mr. Mahapatra?
Yes, sir. Yes, sir. They are visiting every day, sir.
Every day?
Yes, sir.
That the sanitation workers are visiting the 2 colonies every day. Nevertheless, he has also been shown the photographs of the present state of the colonies, which reveal that much needs to be done. So he assures the court that on the next visit of the Amicus Curiae to that colonies, which will be in the last week of December. Is it okay with all of you because it's vacations?
Yes, sir.
At least some of you.
Yes, yes.
2021. The situation in both the colonies would be far improved. Even on the aspect of construction of additional toilets, the collector assures the court that these will be completed by the time of the next visit of the Amicus Curiae. Anything more on this Jatni colonies?
Lord, with regard to the Aadhaar card,
he also states that arrangements will be made for issuance of Aadhaar cards to the inmates in both these colonies by adopting the iris scan method in the next 2 weeks.
and consequently PDS will be given to them alone.
Yeah, this will be followed up with issuance of ration cards to each of the inmates, if not already issued.
Additional toilets, lots of.
I have already. So, thank you, Mr. Mahapatra, and thank you, Dr. Pati.
Namaskar, sir. Thank you. Sir.
Namaskar. Namaskar. So we'll move on to Puri.
Puri.
So we'll play those videos first.
That's why I think if I place those videos actually don't really show anything new. I have attached them because whatever we are writing.
Right.
So they're, backed by. Lordships, the reports have the photographs. Your Lordship, this one thing, actually in the original order, the Puri's visit was actually confined to only Sanjay Leprosy Colony,
Right.
which happens to be again on a railway.
In fact, good you reminded me. In that order, you say a direction is issued that there will be no hindrance caused from any quarter, including the workers of the railways, to the egress and ingress of sanitation workers and other teams that may need to visit the colonies, either for construction of additional toilets or for preparation of the Aadhaar cards, etc. The court also therefore considers it necessary that the Southeastern Railway, right? East Coast Railway, bracket ECR, through its general manager, be impleaded as an opposite party in the present petition, and notice be issued to them returnable on the next date for their inputs. All right. We'll get that Mr. Mishra who appears for ECR. The registry will inform Mr. Anindya Mishra, learned counsel who usually appears for ECR, of today's order to enable him to seek instructions.
Standing counsel Dhanoj Sahu is appearing for the railway, my lord. Standing counsel Dhanoj Sahu.
Dhanoj Sahu. Yes. But for we have one Mr. Mishra coming. All right. Yes.
Lordships, actually, initial order was only confined to Sanjay Leprosy Colony, which is near the station. But one of the biggest leprosy colonies in Puri is also near the Lokhanath temple, which is actually called Jivan Majhi Leprosy Colony.
Okay.
Your Lordship, actually, this leprosy colony is quite systematic because it was actually under the some German missionary father.
Oh,
but after he's left, there's nothing. They also require help. So that's why we thought that visiting that colony will also be right. Your Lordships, actually, as far as the MCR is concerned, that they have been doing, and as far as MCR 2 is concerned, just 2 days before our visit, they have distributed MCR 2. But your Lordships, will look at the garbage and unwanted debris. Your Lordships, I have photographs from page 4, and this is of the Sanjay Leprosy Colony.
No, where is the Puri report? We don't have your Puri report.
Lordship, this report, if that report is Lordship,
I'll give the copy. I'm giving this copy of mine.
No, color. Lordship, we take my copy.
Okay. यहाँ से
This is the same Sanjay Leprosy Colony, Your Lordships. Your Lordships will see this is a garbage. Just when you enter on the right hand side, you will find it. This is like a hotbed of mosquitoes, and in fact, one of them had just recovered from malaria. So that cleaning aspect, with this kind of cleaning, will require not the general municipality, but proper the vehicles have to go in with proper equipment. So this is there. And obviously the broken houses are because they were also hit by cyclones.
Right.
Your Lordships, then the other part was of additional toilets, Your Lordships.
So all of these photographs that you have from page 5
yes,
is Sanjay Colony.
Sanjay Leprosy. That colony is far, Your Lordships, in fact, that colony is worth visiting because, so much of donation has come from all over, people from Calcutta, and it's all there constructed. But today, they also have their problem. I shall narrate that. Your Lordship, but this colony, Sanjay Leprosy Colony, Your Lordships will remember last time also had made a direction about the toilets.
Right.
The dry toilets are still there, Your Lordships. That photograph is at page 8 with date also. What has happened is, Your Lordships, some of them have managed to have the flush toilets, but a lot of them are, dependent on this. And there has been no effort from the Puri municipalities, administrators tried to do so. And they have also written in their report that, we are not doing it because it's a railway land, the railway disputes are there, that's why we are not constructing. They've taken that plea. I can point that out from their affidavit also. So this continues. This was there in the first report also.
Right.
So this continues. Your Lordship, as far as people visiting, the doctors visiting, they have some Ayush doctor who's coming, but they've been visiting. Once a week they come on Wednesday, they've been taking care. But they did complain that, the actually under NLP, they are also supposed to give them this kits for self-bandage because every day they will not be there. So that's not there in either of the colonies. So that I think they can do anyway. That's a mandate under NLEP to give them self-management kits. So that is there, Your Lordships. But Your Lordships, there's other grievances. What has happened is, Your Lordships, those 500 to 700 rupees which they are supposed to get as pension, they have to go to the bank. So that's been a big complaint that's there on the audio video also, that they have to travel to the bank. Both the colony members have to travel. They say, if we have to spend so much of money, and with begging being stopped, they really said that, we need at least 3,000 rupees to manage our medicines, food. And Your Lordships, 5 kg rice, and this is really nothing. That is why you find so many people being anemic and having other conditions. I mean, the regular nutritional support is not enough for them because their age.
So what's the solution as far as the bank is concerned?
The bank is
because there's a system of banking correspondents coming to
Lordships, or a mobile ATM or something like that.
Correct.
Where they can come to these colonies.
Correct.
And actually, when we went there in the second colony,
which is the bank where they have their accounts?
That's something I guess we
because then we can ask that manager to come like this online, and we can ask
that we'll find out.
Next visit.
Next visit we'll do that.
All
I think by the next visit they may not have gone to the bank, so we'll find out.
All right.
But it is somewhere near, I think near that Loknath temple.
All right.
So that's one thing, Your Lordships.
The collector Puri has been given a copy of their report.
No, today morning I have received one.
All right. We'll just send it to him.
The what we found is and which is also, I think, a concern everywhere, is that, Your Lordships, this entire rehabilitation issue, because they are also beggars.
No, we'll come to that. Actually, I was thinking that the health ministry part of this, the health department, because this coming under the social welfare department, and the health department has to be centrally involved.
Lordships.
Because
both the department, social security empowerment department, my lord, and the health department.
Health department has to be very much, because if this minimum, that kit and all that you're saying.
And the food nutrition aspect also has to be seen. It can't be for general poor people. It can't be the same for them.
Correct.
That's why actually they suffer.
Right.
They need more nutritional
They
support.
are only being given 85 rupees, my lord. Earlier they were being given 50 rupees. Now from 1/4/2021, they are being given only 85 rupees per day. And that also dry ration, not even cooked food.
And the problem is, Your Lordships, I mean, begging has been stopped. But Your Lordship, that was their source of income.
Right.
And those videos, most of the videos are actually those old ladies and some of them are blind, some of them have developed diabetes. So they say that if we don't beg, how do we maintain ourselves? So rehabilitation has to come. There is a Sahaya, scheme in state of Orissa, and where leprosy affected people have been identified as a group.
Okay.
So it's not that we are without a scheme and policy. If something can be done.
What was the outcome of that standing committee or something, those meetings?
Affidavit I have filed.
The commissioner comes secretary, that one.
Yeah, they have brought in Baba Amte's representative, so that's work in
Signed by
progress.
Ms. Madhumita Naik. Affidavit dated 25/11/2020.
Correct. She's the additional secretary.
Yes.
Social secretary and empowerment.
National Kanji, paragraph 3. They have taken decisions and fixed the timelines also. May placement.
So everything, health and family welfare department may deploy doctors, may consider inclusion, reconstructive surgery, appropriate cash incentives. So this is now the bureaucracy at work.
No, the SSCPT department also involved.
No. What I'm just saying is this allocation of tasks. See, the point is we treat the state government as one entity and not as several. Because at this rate, we'll have to call individually every department to the court, every secretary to tell us.
No, all is being monitored by the technical committee.
No, but the question is, will the health and family department, welfare department respond immediately to this?
They have been given the timelines to comply.
No. So 18th November, they're given a timeline of 2 weeks.
Yes.
Right?
Yes. 2 months, 2 weeks, 1 month.
See, they only say appropriate cash intensive to newly detected leprosy cases to compensate for loss of livelihood within the next 2 months. Now, all this language will really mean nothing, right? We don't even know what is appropriate cash incentive. We don't even know if the newly detected leprosy cases, we don't know how many they are. What are we looking at? And cash incentive can't be a one-time incentive. It has to be something more systematic and periodic. What I'm saying is the language used really happens. This visiting each of the, I'm told there are what, 70 colonies or 97 colonies?
87 colonies.
The technical committee was to set up subcommittees to visit
Yes, that
each
is
of the
there,
colonies.
paragraph 4.
The subcommittee will take personal visits.
In each district, subcommittees are available.
I think we'll implement the health and family welfare department because so many tasks have been given to them.
And my lord, may kindly see the proceeding itself at page 11.
Yes.
They have also State Commissioner for PWD is Maharashtra, and
Maharashtra,
obtained their
correct.
views also.
Correct.
Paragraph 3. Sri Sanjay Kadam, State Commissioner for
So
PWD.
each leprosy patient receives a sum of 8,000 at the time of detection. They have appointed dressers in the colonies who are paid 2,500 per month. So why can't you adopt the Maharashtra model? What is the response to that? Has the technical committee recommended that?
No, there is no.
That is not.
So there is a Nehru Palli leprosy colony here in Cuttack. So what were you saying on Puri again?
Lordship said one more thing about Puri. I think that requires also an urgent attention because if we are seriously looking at the cyclone, your Lordships will see the last page, page 10 onwards. Your Lordships, all these living homes require urgent attention, Your Lordships.
Correct, correct.
And we...
Yeah, really dilapidated. You say the separate interim report has been submitted. This is also called Lewis, is it? Puri?
Puri is called Sanjay Leprosy Colony, Lewis Road.
Louis Road. is it?
That's Louis Leprosy
Louis
Colony.
Leprosy Colony. The
Colony.
Sanjay-
That is
Sanjay
Sanjay Ji, Louis Leprosy Colony.
Oh, because that other thing is also called Louis, right? In Balaji.
That Bamapada, that's a Bamapada.
No, no.
Baleswar colony.
Louis
Another is
That was also Louis.
Baleswar is known as Louis Leprosy Colony.
It is Sanjay Leprosy Colony.
So it's a
No, that's a mistake on my part.
typo.
Puri is Sanjay. Then the other one at Puri is Jibaramji, which has a higher number of people.
All right. You see,
They are really old people there.
an interim report has been submitted. In colonies in Puri, one being the Sanjay Ji leprosy colony near the station, and the other the Jivaramji leprosy colony near the Loknath temple. The videos of the visit and the interviews conducted with the inmates have also been submitted on a pen drive. Paragraph. The issues that require immediate attention in these two colonies is the are as under: one, removal of garbage and unwanted debris. Two, the clearing out of the small marshy land, the cleaning up of the small marshy land or ditch inside the colony, which is a breeding ground for mosquitoes. 3, construction of additional toilets. The report: dry toilets were still being used in the Sanjay leprosy colony. 6, sorry, next, whatever. While there have been weekly visits by paramedical workers and pharmacists, it is necessary for each of the inmates to be provided with single quotes self-care kits, unquote, so that they can dress their own wounds. It is stated that there are no such visits by medical personnel at the Jeevaramji leprosy colony. 4, the availability of 5 kg of rice per month and rupees 500-700 towards pension is too meager. The monthly expenditure on food, clothing, and medication requires at least rupees 3,000. So the benefits under the schemes for beggars are yet to reach them. Next, you say many of the inmates have to travel to banks to get monthly pension and have to spend a substantial sum for just traveling. Paragraph. As regards the above problems pointed out, now, next you say the conditions of the living quarters, public houses, is extremely poor. Many of those houses, public quarters, require permanent roofing. The court directs us under: Mr. Mudali will forthwith transmit to the collector Puri a copy of the interim report submitted today in court by the Micus Curie. The collector will arrange for sanitation workers of adequate number to ensure cleanliness and garbage removal in the colonies, in both colonies, on a daily basis from now onwards. 3, he will immediately undertake issuance of, no, he will immediately issue instructions for construction of additional toilets in both colonies after assessing the need and the exercise be completed.
No, there is also that railway problem, railway land problem is also there.
Within by the end of December 2021. 4, a direction is issued to the East Coast Railway not to create any hindrance in the visits of paramedical medical personnel, sanitation workers, and others who may need to visit these colonies pursuant to the directions issued by this court. 4, the collector will ascertain from the inmates the bank or banks with which the inmates have accounts. He will consult the managers of those banks to explore the possibility of there being a mobile ATM that can visit the colonies on a regular basis, so that the inmates can have easy access to their own accounts. The repairs of the houses of the inmates in both colonies be undertaken on.
These photographs are only for the Sanjay leprosy colony.
In the Sanjay Ji colony be taken up on an urgent basis and be completed within a month from today. Paragraph. And a compliance affidavit of the CDM and PHO, Puri, pursuant to the directions issued on 2nd September 2021 has been produced. Just put this right in the beginning. Then last, there's also Baleshwar, right? What is happening there? Yes. Lords, may kindly see for Baleshwar.
Before we go to Baleshwar, this one thing may I just point out for Puri, your lordships.
Yes.
As far as they're saying about this railway land problem,
yes.
Actually near this other leprosy colony, which was being managed by the father. Yes. There is still huge land, your lordship, belongs to HKNS plus this machinery. It's not really encroached, but they are not able to utilize it. So government can explore that also and can give them, I mean, as such, it is in the name of the leprosy people only, and construct new buildings and accommodate these people who are there on railways. I mean, just explore that.
Yeah, let the railways come in.
Lordships.
Then we'll look at that.
Regarding Baleshwar, my lords, may kindly see the order dated 2/9/2021, order number 23.
Right.
Paragraph 2, the directions regarding Baleshwar were there. Now, there were 5 directions in all. My lord sees it at this page number 2.
Yes.
Now, so far as the first direction, my lords, that's complied. Now, dump yard and all, that's work in progress. The crucial issue, my lords, is serial number 5. 60 houses with it was specified within 8 weeks from that date, that is 2/9. Here, my lords, this has not been complied with. So if my lords find that at paragraph 2, last sentence.
Right. 1.
So this is something which the time has already lapsed. And if my lord sees the report which we have filed, my lords may kindly take up the follow-up report which we have filed, my lords.
Yes. Page 5.
My lords.
So
Now,
photographs,
my lords, what they have done, page 3 onwards, that looks good. In fact, this is because of the intervention of the learned Advocate General. Last 7-8 days, they have quickly done these 10 houses.
Okay.
But my lords may see 5 onwards, it remains still in shambles.
Yeah, we keep the pressure on. Hopefully, it will all get set right.
Yes, and one thing is para 1 that the raw vegetables and all which they were getting, that they are not getting since 1 month. So if a line, my lords, can add regarding that.
Right. As far as the Lewis leprosy colony in Baleshwar is concerned, the report of the Apex Curie points out that the inhabitants are not regularly getting their raw diet which includes rice, dal, vegetables, edible oil, firewood, etc. And that possibly HKNS is not paying the dues of the local contractor who supplies such items to the inmates. Stop. A direction is issued to the collector Baleshwar to immediately ensure that the supply of raw diet is not stopped for any reason whatsoever. He will also sort out the issue concerning the dues of the local contractor being paid by HKNS. Paragraph, it is pointed out that while steps have been taken to construct new houses. No, all the steps have been taken to, no, all the 10 houses have been constructed and the construction work for another 10 is underway. There is a shortage of at least 13 houses. Stop. The photographs also bear this out. Consequently, a direction is issued to construct the remaining 30 houses as well. At the and to commence this construction forthwith. Stop. The next compliance affidavit of the will include a report specific to the need for construction of additional houses. Paragraph separately, the collector Baleshwar has filed a compliance affidavit. More or less pointing out to the same status of construction of houses. Pursuant to the directions issued by this court on 3rd November 2021, the technical committee held a meeting on 18th November 2021. So proceedings of the said meeting, along with the compliance affidavit of the Commissioner cum Secretary to the Government, SSEPD Department, has been enclosed the compliance affidavit placed before the court today. Full stop. Inter alia, it is stated that the Health and Family Welfare Department has been asked to ensure supply of MCR prepare, semicolon, deployment of doctors and paramedical workers on deputation to the colonies on a regular basis, semicolon, considering inclusion of reconstructive surgery for cured leprosy patients under the Biju Swasthya Kalyan Yojana to enable them to get treated in private hospitals within 1 month. Semicolon. Consider providing appropriate cash incentives to newly detected leprosy cases to compensate for loss of livelihood in the next 2 months. It appears that the committee had inputs from Sri Sanjay Kadam, State Commissioner for Persons with Disabilities, PWDs, Maharashtra, give them who presented the scheme public system in Maharashtra, prevalent in Maharashtra for cured leprosy persons in particular and the PWDs in general. Although the technical committee does not issue any specific directions in that regard, the court would want to have the views of the state government on adopting the Maharashtra model for Orissa as well. The court also notes that a subcommittee has been formed at the level of the district, in each of the districts, under the chairmanship of the collector, and 6 other public servants from the civil supplies, social security, and public health departments. Paragraph. Considering that a number of actions are to be taken by the Health and Family Welfare Department, it is implemented as an opposite party. Through
No, already there, my OP number 1.
They're already OP number 1. Oh.
Unless, in fact,
A direction is issued to the secretary.
May I just intervene, my lords? Here, my lords, there was already a direction on 14/7/2021 for the Director Health Services to file the detailed affidavit.
Yeah,
That direction, my lord had given regarding 4 or 5 heads. That they have not done till today. And in fact, that was also reiterated subsequently on 2/9/2021, paragraph 8. So twice there is a direction to the Director Health Services to give those details.
Specific direction by this court, both in its orders dated 14/7.
My lords,
14/7/2021 and 2/9/2021. No affidavit has been filed by the health department. Consequently, a direction is again issued to the secretary, principal chief secretary health, right?
No, additional chief secretary.
Additional chief secretary health.
No, one affidavit has been filed by the director.
Today?
No, earlier it was filed.
Yes, but not in terms of my.
Right. File an affidavit at least 1 week prior to the next date, indicating the status of compliance with the various directions issued by the court and the action taken, the recommendations of the technical committee at its fourth meeting, as referred to here and before. The additional chief secretary, chief secretary health is requested to remain present on video link on the next date of hearing.
Virtually.
Video link, it's the same thing. The court expects that the subcommittee is formed by the technical committee to undertake visits to the 87 odd leprosy colonies elsewhere in Orissa. Will in fact have completed that task. If it would have substantially completed the task. Full stop. A report of such visits by the subcommittee, enclosing status, the photographs showing the present status of Scotch colonies, will be placed before the court. So we'll have it on 5th January 2022.
Yes, ma'am.
All right. Thank you. Yeah. The collectors of Puri, Khurda, and Baleshwar, including the respective CDMOs, shall be present on virtual mode on the next day.
Would your lordships call it at 2 p.m. minutes?
2 p.m. Correct. Right.
We are grateful.
Do we need the pen drive back, or I think we can keep it?
Your lordships can keep.
Yeah.
Item 21.
They have to go, let them go.
This is a PIL regarding illegal allotment of government plots in favor of the influential and the rich. Though the rule provides priority should be given to the land outage of private class steel plant as well as poor and middle income group. As per the rule, that has been totally ignored, and by phase, different advertisements are made for auction of land. In the earlier occasion, your lordship intervened.
Have they filed the counter, sir?
OP number 1 has filed a counter.
All right.
But I have filed one application for intervention, your lordships. That is IA number 3 of 2021. In earlier date, your lordships was pleased to, my lord, direct me to serve copy upon the.
I have received a copy. I don't have any objection.
All right. Who are these people?
No, the Raulkela Bar Association, my lord.
What is the bar association?
No, we have the same cause as per the petitioner is concerned, your lordships. I have the bar association also has undertaken the same issue and filed application before the ADM. Lordship may kindly see Annexure A of the IA, your lordships.
No,
Annexure
illegal
Y.
allotment of government plots in civil township area is one thing. Why should the bar association get
But it's taken that issue, my lord, that is poor people is deprived. The displaced poor people, landless people.
Before us, that's more than enough, sir.
We have the same cause as like as the petitioners, your lordship.
But why have two people for the same thing?
Because once the PIL is pending, your lordship, we don't want to file another PIL. Therefore, we want to intervene, my lord, to assist your lordships.
No, that if you want to assist us, amicus curiae, you do that. Making your party is a different thing. In a PIL, there's no need for it.
Though, my lord, we
No, we can give you an audience. We can give you as a lawyer. You can say you will assist us as amicus curiae. That will satisfy the requirement.
In fact, my lord, has earlier moved on PIL, and this honorable court has directed and given a particular direction. That is at page 7 of my counter affidavit filed by opposing party number 1. The judgment of the lordship's earlier direction has been there in page 7. Now, his pleading is completely contrary to that particular direction. The same bar association moved this honorable court in a PIL earlier in the year 2010, and now the direction given in that writ application is at page 7 of my counter affidavit. Now the police specifically contrary to that particular direction.
What's the response of the government?
Your lordship will sought for instructions. Your lordship will file an affidavit.
You say IA number?
I may be pardon, my lord. I have filed a IA for intervention, my lord. I am for the land loser displaced family, my lord, who lost their entire landed property for establishment of RSP, my lord. IA number 12265.
Okay, let's see that. This is a steel plant. Everybody wants to get in. There's no need for so many people, sir. You're all saying the same thing, right? You're also concerned about illegal allotment of plots.
But the advertisement would have been, they are giving priority to all these people that is provided under law. That would have proven better. None of the advertisement in the past, they say that some lands have been reserved for these people in lower income, land outage. They never did that. That is what the problem. And they always make auction where these people doesn't have a stake. They cannot compete with the person if land is auctioned and that is given away to some other.
Say 12893 of 2021. This is an intervention application by the Rourkela Bar Association, joining the petitioner in urging that there has been illegality in the allotment of land by the Rourkela Development Authority. A separate paragraph, a separate intervention application has been filed, being IA number 12265 of 2021, with the same relief being claimed this time by the Rourkela Steel Plant and MD Local Displaced Association, -70 villages, Rourkela 42. Paragraph. As far as these two applications are concerned, court is of the view that there is no need to multiply the number of petitioners if the cause being espoused is the same. Full stop. It to be open to the lawyers for this two respective, for the applicants in these two IAs to address the court as friends of the court. The applications are disposed of. What about the main matter?
Main matter, I have received a counter and need to file rejoinder. Counter from OP number 1. Government has not given any counter.
Or a copy of the counter filed by OP number 1 be served on counsel to the petitioner. This is an item 21. Rejoinder, if any, be filed the next day.
May I pray you, Lordship? That a copy of the writ application and counter be served upon us so that we can assist
Writ
you.
application I have given.
So the counter and the
Writ application I have given.
You're just intervening, that's all. Why do you need the counter?
so that I can assist your Lordship if necessary.
No, you're just going to on general points in law. Otherwise, it's the same thing. So he's already there for me.
If necessary, your Lordship. If necessary, additional.
You ask him to give you a copy, then that's the best.
Obliged.
Date is it's the 12th January, 2022.
The interim order will take today.
Interim order to continue.
Item 22.
No, man, my lord, this matter, my lord, my around 3 crore rupees at stake, my lord. Would you lordship kindly direct that be disposal of an alleged matter? I am for the opposite party number 1, and I have purchased the land from government for auction, and the auction has been stayed, and my money is at stake. So therefore, I want an early disposal so that I can either get that by money or.
Can't hear also. So you have to speak into the mic, sir.
I am for the opposite party number 1. Government has given me the land on payment of 10% of the value of the land, that is 3.5 crores, my lord. Now the auction has been stayed. My money has been at a stake, my lord, there.
So you want a release? You want a return of your money?
But no. I only want that let them not linger so that my money will be.
Most of lingering then. Well, what date is fixed for? 12th
January. Item 22.
May I please, your Lordship? 22 counter has not been filed, your Lordship. Last occasion, even direction to the government advocate. That is, all these 3 items are same, identical. That is to include the petitioner in the old pension rule, and counter has not yet been filed, your Lordship. That what the case is squarely covered by the decision of this honorable court in case of Anand Chandra Das versus State of Orissa. That has also been confirmed by the honorable apex court.
I see.
In one case we have filed counter, in 2 cases we have not filed counter. If your Lordship will grant a short time so that we can file counter.
Last opportunity to file counter in those petitions where it has not yet been filed within 4 weeks. Rejoinder, if any, within 4 weeks thereafter. Is there an interim order here?
No interim order, your Lordship.
No. List on 7th February.
Item 23.
My lord, in this case, Lordship can drop this case because already she has been selected and she has been recommended to the government for appointment.
All right. On account of subsequent developments, the petition has been rendered infructuous and is disposed of as such.
Item 24.
May I please, your Lordship? In this case, the petitioners may file this case for rehabilitation under the Street Vendors Protection Act, my lord. This is the opposite party in the last occasion also. I had already served the copy to Mr. Lord and Senior Mr. Vivadendra Das, my lord. Well, the petitioners are carrying their respective street vending activities, and they are also paying the license fees to the municipality, my lord. I filed all the receipts, my lord, at Annexure 1 series.
Who is appearing for the municipality?
My lord, I pray for 2 weeks time to file counter.
See, in many instances later you come and say this apprehension is unfounded, no such action is planned, all that.
Yes, my lord. But
what are the instructions?
My lord, I have not yet received any instruction. As per the Lordship direction, I have received the copy and sent it to the
BMC.
You appeared on 3rd November itself.
Yes, my lord. In the 30 days, you are not granted. My lord, further 2 weeks only.
At the request of Mr.
Bidas.
Dash, Learned Counsel appearing for the BMC. List on 19.
Same prayer in 25.
Yeah, same in 25.
Madam, miscase, my lord. No course of action, my lord, till then.
Is there earlier? Is such an interim order passed?
No, my lord, no.
No. We are not passing an interim order. Yes.
Item 26. Oblige, yours.
Please, Lordship. Lordship, last occasion, Lordship, direct to the state Lordship to produce the status report, Lordship.
Yes. Let's ask. 1 minute.
BMC.
26 plus today in the morning plus.
The Lordship was pleased to admit the questions involved in this case are order dated 23/4/2013, order number 4 bills, and the order bills, the questions which are posed in this is at page 21 bills. There's 2 questions are framed bills. Page 21. There's whether Hajbullah candy is exigible to tax as an Ayurvedic medicine under list A. List A may be read as list C. The other day, I have there is an inadvertent mistake. List C of the Orissa Sales Tax Act. B, in view of stand of the state that Hajbullah candy is nothing but sugar candy, whether levy of tax at the rate of 12% justified when the rate of tax of sugar candy as per entry 154%. Second question, for the timing related flyover, I will not place it. On the last occasion, I have given a bunch of judgments to Lordship, and your Lordship wanted from my royal friend to verify. And if your Lordship, my Lords, kindly see, before I take your Lordship's attention to judgments, my Lords, a brief history will help to resolve, my Lords. First, at the outset.
Mr. Sahu, then we'll take it at the end of the board, okay?
My Lords.
All right.
Item 29. Item number 29.
Item 30, I'm appearing for the respondent.
In which one?
In Read Appeal number 382 of 20.
We'll just pass it over once. We'll just call it after the pass.
Passed over matter, supplemental list, item number 4.
Please, Your Lordship. Look, this PIL is against the putting of the Sairat source to auction
in successive years. But I'm on the VC, my lord.
Yes, yes.
Yes.
We can hear you, although we can't see you. Yes, now we can see you.
My lord. But here, in fact, if your lordship sees, the petitioners approached this honorable court on a previous occasion. That order is at page number 62.
Yes.
And the order starts from page 64, wherein there was a direction to dispose of the representation that was pending and also a fresh representation if the need arises. But thereafter, the collector rejected our representation on the ground that no ground is made out to stop the auction of the Sand Sairaj source. That order is at page 70, annexure 5.
Yes, yes, please.
Yes, Lord. Page 70, annexure order. Lord, before I take your lordships to that order itself, there is a Orissa Sand Policy 2021 which has come out. I have also filed a memo attaching the policies for your lordship's kind perusal.
Yes.
But if your lordship kindly sees, this policy was never referred to by the collector. Be that as it may, my lord, the entire dispute with respect to putting the Sand Sairaj source to auction is, my lord, met through this policy. If your lordship turns to the second page of this policy, this has also been approved by the cabinet as it reads on the last page of the policy. The second page, if your lordship sees, is demand supply estimation. If your lordships have found it.
Yes.
If I may be permitted to place that particular clause, my lord. District survey report, DSR in short, for demand supply estimation and gap assessment of every district shall be prepared by the competent authority for sustainable sand mining as per the guidelines issued by MOEF and CC, which inter alia includes the following. Now, these measures have been put in place by the state for effective mechanisms to be implemented and protection of the sand and river morphology. But my dispute, the grievance of the petitioners is excessive putting of the Sand Sairaj source to mining.
All right, we'll just issue notice. You say notice, Mr. Manti accepts notice for opposite parties. Mr. Manti, you accept notice for all of them, right? Except pollution control.
Except pollution.
All right, he accepts for 1 to 4. Notice will go to the pollution control board by speed post returnable on the next date. 14th February.
May I prefer shorter date, my lords, because the auction is already going on, my lords. Only if your lordship is convenient with the.
Yeah, it won't reach. You say in the meanwhile, replies we filed within 4 weeks, rejoined up for the next date.
Yes.
My lord, your lordship, 14th February.
14th February.
Item 13.
Please, Lordship, this matter, my lords, these three matters, your Lordship, I may be permitted to file better application, my lords.
All right. Council petitioner seeks leave to withdraw these petitions. Liberty to file.
I will approach the authorities, then I will file better application, my lords.
Approaching the authorities first.
My lords.
And later seeking appropriate remedies in accordance with liberty is paid.
Item.
Yes.
Item 14.
Now he's got a proper government.
Lordship, I may be.
Yes.
Lordship, I may be permitted to file an amendment application in course of this week.
Not necessary, sir. You file a fresh petition if you have to.
In fact, the order is revisable under section 30 of the MMDR.
No, there is an order of this honorable court already. Already there is a stay continuing for years. Since there are certain changes of facts.
Effective revisional remedy is there.
Yes. Lordship will hear that.
Because all these facts can be raised before the revisional.
Yeah. The order challenge in the present petition is revisable under the
30 of the MMDR Act.
Section 30 of the MMDR Act.
Before the central government.
Before the central government. Then, meanwhile, counsel of the petitioner states that the petitioner entity itself has undergone some changes.
Yes, there is a new company formed this petitioner company and Vedanta, they have come together to form a new company. By the orders of NCLT, they have also got.
In respect of which there are orders of the National Company Law Tribunal, paragraph, leaving it open to the new entity to seek appropriate remedies as available to it in accordance with law. Since the impugned orders, the court disposes of the present petition. The interim order stands vacated.
Item 16.
May I please?
Yes.
So also look at the 23/9/2021 of filed a date chart with written submission. The case my lord, the petitioner my lord, he is working in the establishment of this honorable court my lord. And he has been denied promotion to the post of senior secretary. That was the subject matter of challenge here. So also look at the date chart. Here also.
Yes, we have it.
Well, 1389 petitioner joined as stenographer in the establishment of Orissa High Court.
Right.
9/2/1990 promoted to the post of senior stenographer. 3/9/1996 promoted to the post of personal assistant. 1/4/1997 became a confirmed government employee. 6/5/2008 promoted to the post of secretary. Then 27/2/2015 Orissa High Court appointment of staff and conditions of service rules 2015 has been amended, repealing old rule, that is the Orissa High Court Orissa appointment of staff rules 1963. 3/2017 notification was issued for convening the DPC for promotion to the post of senior secretary. 31/3/2017 DPC convened its meeting for the post of senior secretary. Then 31/3/2017 notifications were issued promoting opposite party number 4 to 9 to the post of senior secretary, even though opposite party number 4 and 5 had no eligibility qualification. They are not bachelors in, that was this requirement as per the new rule. Then 31/3/2017 opposite party number 4 to 9 joined in the post of senior secretary. 6/4/2017 petitioner submitted representation to the Honorable Chief Justice for consideration of his case for promotion and restoration of seniority in the cadre of senior secretary. 23/3/2018 representation of petitioner was rejected on the ground that since the DPC has already considered his case, his representation merits no consideration. Then 27/3/2018 petitioner sought for information in the RTA Act regarding his
He retired as additional deputy registrar.
Hello?
He's got promoted to the cadre of additional deputy registrar come additional principal secretary.
Yes, he has been.
So now he's retired.
Now he is retired.
But
this is
now.
The case is, my lord, if I will succeed in getting, my lord, the promotion which was given on 31/3/2017, my lord. For promotion, my lord, to the post of higher post.
No, now it's all, you've retired now, sir. So it's only some monetary benefits you're going to get.
But simultaneously, I have been denied. my lord. If you also look at the rule.
No, the net result of all this will be some monetary benefit, correct?
If you succeed in the matter, you will get
But
only monetary benefit.
that is correct, my lord. But the petition is still continuing. my lord. This petition is not retired.
Just asking you that, you said yes to begin with.
Who is in service?
No, those men who have been given promotion out of it, two have been retired in the meantime.
All right.
I'm still continuing. my lord.
That's what I asked you, sir.
Initially, my lord, after.
Maybe there's some.
So you impleted 4 to 9.
Yes, sir.
They will be affected if you succeed.
Yes.
Who is representing them?
No, sir. After that, by 16/1/2019, further consideration was made for further promotion. My case was not considered. And surprisingly, 4 and 5, those who have been given promotion in the first DPC, they were denied promotion on the ground of the additional qualification. So, in case of Jagannath Sahu, the issue has been settled. If you also look at the rule, a rule has been annexed, my lord. If you also look at page 35, page 35. There was an explanation, my lord, to the rule 1. The rule may be called Orissa High Court Appointment of Staff and Conditions of Service Rules 2015 and shall come into force on the date of publication of official gazette. Explanation: nothing in these rules shall adversely affect any person who was a member of the service on the date of coming into force of these rules. Keeping this explanation in view, my lord, 4 and 5 were given promotion in 2017 March DPC. That was the subject matter when he was denied. The same person, Jogna Sao, denied promotion, further promotion, my lord. He approached this honorable court and the judgment was delivered in his case, my lord. So there, my lord, the High Court accepted, committed in that DPC, my lord, which is the subject matter in my case. If you also look at the judgment I have given, it is a part of the my lord's record, my lord. The judgment is there. (2020-22) ILR Cuttack 197, my lord. That explanation, if you also look at the judgment, that is
No, 1 minute. It's part of your paper book.
No, it's not about. A bunch of judgments has given, my lord. It is there.
Let's see. Yes, 4 proposition.
Para 7, my lord. The Orissa High Court Appointment of Staff Rules 1963.
Which judgment? Para 7 or which judgment?
Jogna Sao.
Reference?
Para 7.
No, reference?
There is, my lord, to 2022 ILR.
ILR you have not given. All these are AR citations. AR and SCC. There is no ILR reference citation.
You remember that was referred to on 39/20/21 orders.
No, it's not there. The one which you have given. No ILR citation.
Can have it on some other day?
Is
Is there a hurry in this matter?
No,
he's already retired. It's only some monetary benefit.
No, well, I am still continuing.
Oh, he's not.
Monday, next Monday.
In fact, on 25/3/2021, your Lordship have appointed myself and Mr. Rath, my senior friend, as a amicus curiae in this matter, only for a limited purpose, that 2022 ILR Cuttack 197, the correctness of the judgment only we will address to your Lordship.
Oh, I see. When were you appointed? Which order?
As your Lordship like, or any
no. Which order? Which order?
Order dated 25/3/2021, order number 21.
Yes. Oh, okay.
That 2022 ILR Cuttack, we are of the opinion that we need the assistance of senior counsel. That's
correct.
Minors may fix up any date as minors chooses.
All right.
And recently, that has been settled by the Honorable Appellate Court in the judgment I have given along with my written submission. I have also handed over 2 copies, to Mr. Ratha and Mr. Rautray.
Okay. Okay, list on 11 January. Copies of the judgment in Jadunath Sahu. 2022 197 be placed on record. All right.
Item 28.
The question, let me repeat, Virat.
Yes, yes.
Page 21, Virat. Whether Hajmola candy is exigible to tax as an Ayurvedic medicine under list A, maybe as list C of the Orissa Sales Tax Act. Second question, I am not reading. Let me try over for the time being, madam. The whole issue related to what is the definition of drug? Lordship, I will take my Lord's attention. That is at page 46. Page 46, Lord. Page 46. The definition of drug. It is mentioned in a judgment. I am just referring to that. Definition of at the middle portion, Millers. Drug as defined in clause B of section 3 of the Drugs and Cosmetics Act 1940, Act 3 of 1940, and Ayurvedic, homeopathic and Unani medicines 4%. These Ayurvedic, homeopathic and Unani medicines, these are added by way of amendment on 21/4/93 Millers. Now, Millers, what is 3B Millers? 3B Millers. You will kindly see page 49. Clause B of section 3 reads as follows. All medicines for internal or external use of human beings or animals and all substances intended to be used for or in diagnosis, treatment, mitigation or prevention of any disease or disorder in human being or animals, including preparations applied on human body for the purpose of repelling insects like mosquitoes. So this is how the language of 3B stands, Mirage. Now, Mirage, this is a case, the original assessment, Mirage, my claim was accepted. Now, in the reassessment, as per the audit, Mirage, audit objection, the question, Mirage, revived. Mirage, now, in assessment, they have imposed tax at the rate of 12% under residual entry on all the items which this company deals in, Mirage. Mirage, in appeal, I succeeded. And thereafter, your Lordship will see, SCST Assistant Commissioner decided, this, and now against the state preferred appeal for the tribunal, and the Lorraine Tribunal's finding, I am straightway taking your attention to Lorraine Tribunal's finding, which my lords will find at page 36, Page 36, paragraph 7, minus. We are persuaded by such decision of the West Bengal Taxation Tribunal, in view of the aforesaid, we are of the view that these two appeals at the instance of the state that Hajmola candy is not an Ayurvedic drug or medicine, but a hard-boiled sugar candy coming under the entry of confectionery, and as such, the same is liable to be taxed at the rate to which confectionery items are taxed. In such premises, we have no hesitation to say that the learned SCST aid in holding that Hajmola candy is an Ayurvedic medicine and as such liable to be taxed accordingly. Now, if your Lordship will kindly see one page 35, page 35. Page 35 of the Learned Tribunal's order. Learned Tribunal has relied upon paragraph 8 of that tribunal's judgment. Learned Tribunal has quoted this. I will only pressing some lines from that. Paragraph 8, it appears that Learned Senior Standing Counsel for the petitioner company has based all his argument on the decisions of SEGAT and the Apex Court and other courts regarding classification of a product as a medicine under the Central Excise Tariff Act. In the Central Excise Tariff Act, under Chapter 30, it has been mentioned that the products manufactured exclusively in accordance with the formula described in the book specified in Drugs and Cosmetics Act 1940 are to be regarded as medicaments medicine. Then in the West Bengal Taxation, West Bengal Sales Tax Act entry 24, only mentioned drugs and medicines except those specified elsewhere in this schedule or any other schedule. There is no mention that products manufactured in accordance with the formula described in the authoritative textbooks specified in the Drugs and Cosmetics Act are to be treated as drugs and medicines. Let us pause here for a moment, Millers. Your Lordship will find entry 24 of West Bengal Sales Tax Act totally Millers deals with a different footing altogether than entry 37 of Orissa Sales Tax Act, which defines drugs to mean Section 3B of the Orissa Millers Drugs and Cosmetics Act. And 3B, which has been dealt in by this honorable court earlier also and several other courts, Millers. 3B says that it's an inclusive definition. Not only Millers the medicines, but all substances that helps in curing, mitigating, preventing, that comes on definition of drugs. And not only that, Millers, it also from 21/4/93 includes Ayurvedic, Unani, and Siddha medicines. Now, Millers, so far the history of this is concerned, in paragraph Millers, in paragraph R of my application, Millers, for the earlier period 95, 96, and 96, 97, paragraph R I have mentioned. For these two periods, Millers, I have succeeded in appeal. There was also demand on equal ground, Millers. I have succeeded to appeal before the first appellate authority. Millers, the state was accused, even though the order was appealable, they remained silent. They didn't choose to make further appeal, and the dispute stood at rest. Now, Millers, again, in paragraph S of this petition, I have mentioned for the period of 1991, 91, 92, and 92, 93, Millers, again on the very self-same issue, even though the issue was dealt in and accepted the original assessment, this was revived, and that reassessment order was challenged before this honorable court. I have mentioned detail in paragraph S, without Millers reading all those, just I am submitting for Lordship, Millers. Millers, all those three reassessment orders, Millers, in paragraph S I have stated, when challenged before your Lordship have Millers delivered a judgment, which is a reported judgment, of course, in 1997, 104 STC, page 198. Your Lordship set aside all the reassessments made and directed the assessing officer to redo assessment, taking into consideration the drug license which was issued by the competent authority, Millers, for this item, Millers, that is to be considered. Number two, your Lordship said that Section 3B is to be considered, Millers. So accordingly, Millers, after this or judgment of your Lordship, Millers, again when the set aside assessment order was passed, and in the reassessment order, Millers, everything was accepted. All products, I have been dealing with several products, Millers, except Millers, Lal Dantamajan, all things are accepted. Now, Millers, thereafter, what happened, Millers, and when the reassessment gave rise to some refund, Millers, this department preferred to revise by way of suo motu revision. Millers, that was challenged before this honorable court once again. That was challenged in Millers WPC number, in paragraph S I have mentioned, in OGC number 732 of 96. And this honorable court again set aside the order saying that only the scope of revision is that if the reassessment made is not in consonance with the judgment of this honorable court, then to that extent you have power to revise, otherwise no. So thereafter, Millers, again Millers, the assessing officer, keeping in line the judgment of this honorable court, Millers said that this is to be taxed at the rate of 4%. And for all these periods, Millers, 91, 92, 91, 92, 93, this dispute pertaining to Millers levy of tax at the rate of 4% on Hajmola candy led to rest. Accepted, no further litigation by the department satisfied Millers. Now, Millers, I have given directly judgments which covers this item which is before Lordship. My Lords, in this first application is concerned for the period 93-94, Millers. Other applications, Millers, concerns different other periods, or this 1994. Now, the bunch of judgments which I have given by way of compilation, Millers, I will take your Lordship's attention to that, Millers. Dabur India Limited versus Collector Central Excise, Ghaziabad. May my Lords, see this, Millers? My Lords. Millers, the first judgment is of that of Segat, Millers, 1994, 71 ELT, Millers. Millers, the question number 2 is a question post.
So this is a SIGAT tribunal order.
Absolutely, Millers. Segat, and as my Lords knows, a classification issue, tribunal is the final authority, Millers. No appeal lies before the High Court, directly appeal lies before Supreme Court, Millers. Right. Then I will take your Lordship's attention to other question. Just one, yes, paragraph 2, Millers. The point to be considered in this appeal is whether the product Hajmola candy manufactured by the appellant is classifiable as subheading number 3003.30 as Medicapent as claimed by the appellant, or under subheading so and so centralized tariff as per revenue. The findings, your lordship will find on careful consideration of the submissions made by both sides with reference to the facts and case law. We find that this issue has been covered by the decision of the Madhya Pradesh High Court in the case of Panama Chemical Works, as it was rightly pointed out by the Appellant's counsel, since the ingredients of Swad and Hezbollah are one. Swad is also similar to Hezbollah minerals. Swad and Hezbollah are one and the same. We are not inclined to take different view on this issue. It is not even the case of the department that ingredients of Hezbollah are different from Swad. The Honorable High Court, after examining the ingredients of the item with a reference to provisions of Products and Cosmetics Act, authoritative Ayurvedic textbooks, and experts' opinion, arrived at the conclusion that it was not an Ayurvedic medicine. No contradiction of any High Court or Apex Court with reference to the item in the question or of identical goods have similar ingredient placed before us. The position would have been different if it was so. In the absence of any contrary decision, respectively, we are following the decision of the Madhya Pradesh High Court on this issue. Accordingly, we hold.
No, this position holds good even today.
This position, to my opinion, holds good today. I have tried a lot and I didn't find anything. And your lordship have also asked my friend to examine also.
Yes, yes. No, so let him, Mr. Sahu, let him therefore answer, because last time itself we noted some of these decisions. Last time, in our last time's order, we've already noted this Panama chemicals and all that.
Correct.
And we asked him to find out if there's any appeal against that.
Correct, Vilas.
Yes, Mr. Padi.
The position still holds good. That the position settled in that order. That holds good.
All right. Anything else you want to say then?
Yes. Here the petitioner has a drug license for this Hezbollah candy.
Right.
And the reliance also placed by that West Bengal Taxation Tribunal on
correct.
That also is not perimeter with the Orissa.
Correct. All right. So we allow the revision. All right. Question is answered in favor. I'll pass the detail. All right.
So question, the first question, that is.
That's right. First question.
Second question not pressed.
May not be. Yes.
Second question is not pressed.
All
the four
are different years, Miller.
All the four different periods only.
All right.
And section is different because first period is 12/8, others are 12/4 minutes.
Okay.
Item 29. item 30.
As I said, my lord, I'm appearing for the respondent here, and my client is due to retire in the month of April 2022.
April 2022.
My lord.
Oh,
Next year, 4 months only.
So who's for the appellant, Central Bank?
In this case, my lord, I may be pardoned to mention, my lord. In this case, Mr. Senior Counsel, Mr. Patwala has to, he's only VC, my lord. I am saying that he is not appearing, my lord. I pray your lordship may take this matter on some other day, my lord. Mr. Patwala from Delhi, my lord. He is in the link, but I now see that he is not in the link.
All right. The court is informed that Mr. P.S. Patwalia, learned senior counsel, who is to appear for the appellant, has been unable to join in the virtual mode. It will have to be in January then, Mr. Ratha.
My lord, can it not be in the month of sometime December, my lord? He's going to retire. Anything, if at all he gets something, lord.
You keep it in the first week, 6th January.
As your lordship, please. But your lordship, kindly be kind enough to note peremptorily, lord. Otherwise,
all right.
My lord, I have my anxiety.
All right. List on 6th January. All right.
Obliged.
My lord, there is a special list. Your lordship has 2 matters, your lordship, for admission, fresh admission. Writ appeal, 2 writ appeals.
One. Correct. Yes. Where is Mr. Jena is here? Yeah, he is there on the video link.
Yes, my lord, I am here.
My lord, your lordship may turn to page 13 the order.
W8 of 2021.
I am giving, my lord, the judgment of that. And also similar order passed by my lords. I am giving the judgment of Union of India versus Janki Raman. And the judgment of our division bench in 2 cases.
So, Mr. Jena,
this is regarding that pendency of vigilance case. In one case, you are also already granted stay and also issued notice.
Correct.
Right.
You say notice. Mr. Jena, you accept notice for one opposite party.
For Padmalochan Pradhan, my lord, may I pray, my lord, my client is retiring in the month of June 2022, my lord. Here, my lord, the departmental proceeding was initiated in the year 2011, and the DPC has already been convened in 2016. But so far, the inquiring officer has submitted the inquiry report exonerating the petitioner. And in spite of that, my lord, they have not finalized the department proceeding. In contrary, my lord, now
criminal vigilance case is pending.
So may I pray, I don't kindly call this matter on 14th or 15th of this month, so that it can be disposed of.
One vigilance case and another is departmental proceeding. And your lordship knows that even if he is acquitted in that departmental proceeding, if the criminal
What's
case.
the status of the criminal case?
Vigilance case, madam.
Criminal case.
Yes, madam.
What is the status of that? Mr. Jena,
no charges have yet been issued, my lord. No charges have been issued. And that is department proceeding, my lord. The inquiring officer has submitted the inquiry.
No, Mr. Jena, we are now on the vigilance case only. The vigilance case is still pending.
Yes, that is the reason, my lord. The circular, they have not enforced. The circular says that since only because the department vigilance case is pending, they cannot debar the petitioner for giving promotion. That is the
not for debarring. The seal cover procedure will be followed. That's all. Nobody is debarring you from promotion, sir. Anyway, we'll issue notice. You say,
Basing on the
Notice, Mr.
circular
Jaina.
dated 17/6/2021, my lord, this is the GA department circular, recent circular, and the honorable single judges are allowed because this where it has been specifically mentioned that long continuance of the will not debar the petition to getting promotion. So now the petition is in verge of retirement. So my lord, even if my lord, after some week they will be what benefit you will get. And this is their document, my lord, 17/6/2021. Sorry, my lord, your lordship will keep this matter on the 14th. I can argue the matter by producing the circular as well as
all right.
can be
You say
disposed
for
of.
the reason stated in both the applications, for the
My
reason
lord-
stated here.
My lord, next application, my lord, the next connected application I am appearing, but this was not been listed. I was no prior knowledge that this will come
Only
under.
today we issuing notice.
No, my lord, in my case, there is government review committee sat and decided that if promotion will be granted, then there is been not hampering the public interest. In my case also, my lord, due to that Western Orissa strike, my vigilance case is there, and that could not be, my lord, for last 15 years that vigilance case is continuing. So even if my lord speedy trial is there, and I wanted that it should be disposed of, it should be decided, but not, no departmental proceeding is pending against me. So let a copy of that, my lord, be given to me so that one day, my lord, it is maybe in the list. At least I come prepared on that day.
No, we'll come, we'll keep it all together only. We just, if the delay is condoned, then you see she accepts notice for the respondent in 889, Mr. Jaina in 888. You see, list along with
No, this
WA
is two,
656 of 2021.
these two different cases. There's nothing to, my lord.
They're all, you may not be aware, but they're all similar.
Similar.
They're all
My lord, my
individual
case
cases.
is by 3-4 times, my lord, my
I
case
know,
is
but
covered.
each will be taken up individually only.
Yes, yes, my lord, that's it. So it may be delinked and your lordship may keep it to next week and I will come prepared on that date, it will be disposed of.
All right. No, we'll keep it definitely. You say till the next date of hearing, the impugned order of the London Civil Judge shall remain stayed. Say list on 8 February 2022.
Much little.
Copy of the appeal paper book.
Yes, no copy, my lord, nothing, my lord.
We are saying that copy of the appeal paper book be served on Ms. Mahapatra and Mr. Jaina, respectively. All right.